in terms of what has been proposed by the Acting Deputy Chief Justice in terms of the protected time of half an hour, that is going to be divided between myself for 25 minutes, and Mr. Villiers will have 5 minutes of that time. If I can just mention the Guillaume question at the outset, that this has been dealt with comprehensively by the Minister, her written submissions. We don't intend addressing Guillaume in considerable detail, but there are one or two observations that we would make, and there are certain points on which we differ with the Minister and where we differ in emphasis. If I can begin by dealing with the spatial justice question. In terms of the requirements for an application for leave to appeal, an important consideration is the importance of the case, and that's where I would like to begin my address. Professor Parnell has given undisputed evidence that the centre of Cape Town is vastly less densified and diverse than it was 50 years ago. She's also given uncontested evidence that in the absence of any overarching strategic plan dealing with the use of state land, decisions around state land have largely pivoted around the provincial government's urban regeneration program. And that evidence is also uncontested. The city admits that the policies that it pursued for over 20 years, since 1994, have exacerbated the spatial injustice in central Cape Town. And the same applies with even greater force pursued by the provincial government. What are the implications if this court doesn't intervene and doesn't grant the applicants the relief that they are seeking? At present, there's no comprehensive plan for state land in the center of the city. And what we do know is that there has been a substantial breakdown between the province and the city and the national government. And what we have at the moment is the polar opposite of the coordinated and comprehensive program that is necessary to address the legacy of spatial apartheid. So we would suggest that it's not difficult to predict that if this court does not intervene, that gentrification identified by Professor Parnell will continue unabated. The attitude of the province to addressing spatial injustice is articulated by Ms. Gooch in her, and their approach is that it's a long-term problem, that it's going to be dealt with incrementally over a long period of time. But she concedes that developing small parcels of land around the city is unlikely to have much impact. The approach of the city is slightly better, that the city manager, Mr. Mbandazayo, he states that undoing the effects of apartheid spatial planning is a complex process which will require a multi-dimensional policy and program which will need to encompass all levels of government. It is common cause that state land is a necessary ingredient for developing the affordable housing that is necessary to address the problem. And it is clear that there is a substantial amount of state land in and near the inner city. In order to deal with available state land could make a substantial impact. And so to return to the question of the importance of the case, we would suggest that this case has the potential to change the face of the city of Cape Town. That if the relief sought by the applicants is granted, we would submit that in 100 years' time there is a good prospect that the city could look like a very different city if the relief is not granted. Moving on from the importance of the matter, I'd like to briefly address the question of what is the critical date for purposes of the determination of the merits of this application. The city say that the application is based on such outdated information that there is little point in granting the applicants the remedy that they are seeking. That we submit is missing the point. That it's clear from the Grootboom judgment that the merits of the application are determined from the date on which the application is launched. The Grootboom application was launched in May 1999, and the Accelerated Managed Land Settlement Program was not in force when the proceedings commenced. But it's apparent from the judgment that counsel stated that by the time that the hearing had, by the time the matter was heard before this court, that program had since been adopted and was being implemented. And the declaratory order that was issued by the court in Grootboom stated that as at the date of the launch of the application, the state housing program in the Cape Metro fell short of compliance with the constitutional obligations, and that a program such as the Accelerated Managed Land Settlement Program should be put in place. And this is also apparent from paragraphs, the critical date is also apparent from paragraphs 39 to 41 of the Mazibuko judgment, which is referred to in our heads of argument. So to come back to the cities, that the merits of the application are determined with effect from May 2017. The fact that things might have moved on from then, and we're not quite sure what has happened since then, because there's very little information before the court since the answering affidavits were filed in mid-2018, and the replying affidavit was filed later that year. What has happened since then is relevant with regard to remedy, but not with regard to the merits of the application. I'd briefly like to address the question of the provincial government and the case against the provincial government. And I'd like to do that simply by highlighting the issues that we submit they fail to address adequately and attempt to skirt around. And the issues are threefold. Firstly, the policy, the effective policy that was followed by the province in the period between 2010 or 2012, it's not quite clear from the evidence, and the decision not to resile from the Tafelberg sale in March 2017, the policy of no P in the city, the reasons why that policy was abandoned, And we told in heads of argument from the province in this hearing that the province has abandoned the regeneration program. We have no idea on the evidence before this court as to what has replaced that regeneration program. And we've got no idea of what the reasons are for the abandonment of the program. That is all inconsistent with the principles stated in Mazib, the duty of government to account for the implementation of socio-economic rights. The second issue that the province doesn't deal with adequately is the breakdown in relations between it and the city over the Tafelberg sale. And the third issue that we would like to highlight is the absence of any comprehensive and coordinated plan for affordable housing in central Cape Town. To move on to the city's position, our submission is that the starting point is the Commando judgment, in which three core findings were made. Firstly, that the location of land and spatial justice cannot be ignored. And the third finding is the fact that not a single emergency housing development has been built in the last 30 years negates the reasonableness of the measures taken by the city. And exactly the same consideration applies to social housing. Not a single social housing development has been built in the inner city in the last 30 years. And it's our submission that that really is the end of the argument. We needn't go any further than that. That constitutes a failure of implementation, to put it within the analytical framework developed in Provincial. And we would submit that there's no answer to that. In the city's heads, they make the submission that there's no obligation on the city to redress spatial apartheid in either the Housing Act or the Social Housing Act. That position can no longer be defended in the light of the findings in Commando in respect of adequate housing in terms of the Housing Act. Requires location to be taken into account, and the judgment highlights the importance of redressing spatial injustice. It's also, the position is entirely inexplicable in that it seems to be completely inconsistent with that were 2017. In May 17, the Built Environment Performance Plan, or with the BEPP, I think I might have got there, and also the September 2017 prospectus for affordable housing in the inner city, and that articulates an intention, at least on the part of the city, to address the issue of housing in central Cape Town. The city, in its heads of argument, also makes the submission that the statements of former former Councillor Heron in the supplementary founding affidavit are no more than the personal views of Mr. Heron. And our submission is that this is not a defensible argument on the part of the on the part of the city. Apart from the statement that it wasn't a difficult process to release city land for affordable housing, and he couldn't explain why it had taken the city so long to do that. In almost every material respect, the statements in the supplementary founding affidavit relied upon by the applicants are confirmed either in the 2017 BEPP or the Inner City Housing Prospectus, or in the answering affidavit. And I'll give an example that the city had fallen short with regard to spatial transformation. In the city manager, Mr. Mbandazayo's affidavit, he concludes that the affidavit by saying that the plans for social housing in Woodstock and Salt River are in place, but he acknowledges that not enough has been done. Still are forced to commute and not follow because the city has not provided sufficient housing in the inner city and surrounds, that it has not met its constitutional obligations. And we would interpret has not provided sufficient housing in this inner city and around surrounds. And Mr. Mbandazayo states that the human settlement delivery approach of the city has been reconceptualized in the context of a focused and accessible town that the applicants have placed before the definition of Central Cape Town that the applicants have placed before the court. But he doesn't explain how exactly the two might differ. He's rather coy about the boundaries of the accessible urban inner core. And access to state land is at the heart of the case, and we've made that submission in our heads of argument. And in our response to the series submissions, we point out that the obligations of the national and provincial governments in terms of the legislation at issue do not encompass the identification and designation of land for affordable housing or providing access to land for buildings for social housing. And it follows that the failure to discharge these obligations with regard to land in the centre of Cape Town rests squarely on the city. And the shortcomings in the city's policy in this regard are very clear from the BEPP at page 2388 of the record. It states that the city is in the process of developing an inner city's human settlement strategy. So this is at the end of May 2017. The application was launched at the beginning of May 2017. So one can clearly deduce that at the time the application was launched, there was no inner city human settlement strategy in place. And then in relation to the pipeline of projects and land, on the same page of the record, the city states the following. Investigation has revealed that the forward planning functions that are required to have a consistent pipeline of both land for human settlement projects as well as human settlement projects themselves in accordance with identified needs does not exist. Through the ODTP, it's a new unit to undertake these functions has been created and is in the process of being filled. Further, a pilot land identification mechanism is being reviewed with the aim of mainstreaming it. Justice. I know that I'm Acting Deputy Chief Justice. I know that I'm running out of time. Shall I hand over to my colleague, and then I could be in a position to take questions.
Acting Deputy Chief Justice and Justices. This matter also concerns the public participation process that Province follows when it decides to dispose of land. That process is provided for in the Western Cape Land Administration Act. The Act itself provides for a notice and comment procedure, and in terms of those notices, interested parties are called upon to make submissions in respect of a proposed disposal. And the words proposed disposal is important for present purposes. The regulations made under the Western Cape Land Administration Act set out a fairly detailed procedure for offers and acceptance in relation to disposal of land. That process, as we know, culminates in the Cabinet taking a decision whether to approve a sale, and if so, the MEC signs the contract of sale. Up until that point, there's no public participation. The regs don't provide for it. And what the regs then provide for is what SERI refers to in its submissions as effectively a deeming provision. The regs say, now that the contract's been signed, Cabinet's approved the sale, it's a proposed disposal, which effectively is a deeming provision because all the details of the transaction have been concluded, the deal is buttoned down, the contract has been signed. And on the facts of the Tafelberg case, when one looks at the Cabinet submission that was made for that very first Cabinet decision of November 2015, there is nothing in that submission that refers to a notice and comment procedure to be followed, that the sale might not be a completed sale, and when one looks at the resolution, it approves the sale to the school for 135 million, but also does not say that it is still subject to meant to follow, or that in fact the transaction might come back to Cabinet again to decide whether to resile from the transaction. Province places a lot of emphasis, as we know, on this right to resile. Effectively, it's a unilateral opportunity for Province to decide whether to pull out of what is effectively a done deal. In the High Court, Judge Gamble dealt with the reasons why this provision, Regulation 4.6, read with 4.1, was ultra vires the Western Cape Land Administration Act. That was, of course, overturned by the Supreme Court of Appeal. But I think what bears emphasis is, as the common law jurisprudence shows, there's a natural inclination, once a decision has already been taken, to adhere to that decision and to have to persuade the decision maker that it was wrong. In a sense, there's already a bias in the decision making. And that, we say, is ultra vires, that Regulation 4.6 is ultra vires the Western Cape Land Administration Act notice and comment procedure, which again, as I mentioned earlier, provides that procedure in relation to a proposed disposal. And in the High Court, the judges looked at the literal meaning and the grammatical meaning, with reference to the dictionary of what a proposed disposal means. Because of time, what I'd like to do is just move on to the importance of public participation in these types of decisions and procedural fairness. The procedure provided for in these regs we submit is not meaningful public participation and does not meet the requirements of procedural fairness. This court has in many cases recognized the importance of participation in decisions that affect the rights and interests of people, and it's a general theme that runs through the Constitution and has been given effect to in many decisions. What we say is that meaningful and fair public participation in this context requires public participation at an early stage of the process so that there can be a meaningful opportunity to influence the decision before the decision is made. In this type of instance, such a stage would then enable parties commenting to, in the first place, comment on whether a sale or a lease or whatever the transaction may be is appropriate in the first place. Should province maybe not retain the land rather than sell it? Or, for example, if there is going to be a disposal and a sale, how should that be done? A tender process on a price BE split, or, for example, a transaction that would include a social housing or affordable housing component. What could that look like? Those sorts of aspects to shape what the proposed disposal may look like. I emphasize in the procedure provided for in the regs, once notice and comment takes place, all that you can effectively comment on is, province, we say you should pull out of the sale or you should not pull out of the sale. So when we look at the cabinet decision in this case that was taken in March 2017, it was a decision whether to resile from an existing contract of sale. Just to mention very briefly, at municipal level, under the municipal asset transfer regulations, there's a two-stage procedure. The meaningful public participation takes place at the very early stages, and the municipal council decides, in principle, is it a good idea to dispose of this piece of land? What are the essential services we provide? Do we need it for that? Public comment is called for, and council takes a decision. Then, if council says yes, let's go ahead, in principle, we give this approval. The regulations then provide a tender process can then take place for the disposal of the land, and ultimately the matter comes back to council to take a further decision. That's just an example of how meaningful participation could be structured. In conclusion then, in our submission, public participation at an early stage accords with the meaning of proposed disposal in the Western Cape Land Administration Act. We say that Reg 4.6 read with 4.1 are invalid and unconstitutional, and in these circumstances, early participation would be meaningful and procedurally fair. As the court, please.
About subsidiarity, Mr. Hoffman. I've got in front of Ms. Pluma, because my reading from your submissions is that there is no specific legislation that you could have relied on. But when I look at Pluma, it does refer to section 25 and section 26. Couldn't you have attacked Pluma instead of saying and other legislation? I know that in your notice of motion, you make reference to other legislation. So you're not really making reference to the Constitution alone. In your notice of motion, for instance, you say, yes, in page 2, you say that there must be a declaration of a failure to comply with the Constitution, and then you say to the end to the legislation enacted. But could this notice of motion not have been specific as to what legislation you are relying on, so that there isn't this complaint that was dealt with at the SCA, and I've had an impression that the SCA thought that you were wrong as well. If we had been specific, and why were you not specific? And why should we found that you did not plead your case in a proper way, and therefore that you are going to be hit by subsidiarity?
Justice Chikhi, if I can respond to that by stating that the starting point in addressing the question of subsidiarity is very similar to the starting point that this court adopted in the commando matter. And in the commando matter, the court reasoned, the SCA reasoned that the applicants in that case, they couldn't identify a right to emergency housing in the legislation that they relied on. And therefore they had resort to Section 26 of the Constitution. And that was not permissible in terms of the principle of subsidiarity. If one has regard to this court's judgment in Commando, it's very clear that the central issue there is a failure of implementation, a failure to implement policies, and it's also a failure, one aspect of it is a failure to have a reasonable policy in place for the inner city. But if one looks at the terms of the order and the repeated emphasis on the failure of implementation in the judgment, we would submit that the same is exactly applicable to this case. The applicants in their founding affidavit say this case is primarily about the failure to implement. And then after the city and the province have set out their case in their answering affidavits, at the start of the applicant's replying affidavit, they summarize what their position is. And the replying affidavit starts with a summary of the evidence of the policies and the relevant decisions that were taken. And then it deals with the shortcomings in the policies adopted by the province. And then it deals with the shortcomings in the city's policies, which I've addressed in my earlier submissions. And then it deals with, there's a section entitled Failure to Deliver, and in that section it deals with the failure to implement affordable housing policies in central Cape Town. And what the submission would come down to is that it's stated explicitly in that part of the replying affidavit that the applicant's concern is not with the legislative and policy framework which has been established by the national government. That is not the object of this attack. But it's the implementation of the policies by the city and province that is under the spotlight. And if one has a look at the facts of the case, it couldn't be that a failure to implement appropriate policies and formulate reasonable policies in one city, one provincial government and one local government could have the effect of undermining national legislation or suggesting a shortcoming in national legislation which spans the country. And so for that reason, we would submit that the question of subsidiarity does not really arise in this case. Like Commando, it's a case dealing with implementation.
Well, yes, that is the trust of the case when one reads it. Well, you know, I just wondered when I was reading the notice of motion why it was just not specific. Because when you just look at the notice of motion, not having read the complaint is all about, then you then think that maybe the SCA was justified in its criticism and in its approach of subsidiarity. At the end of the day, I agree with you that the trust of the cases was the province and the city had failed to comply. That is the trust of the case, but the way it is pleaded in the notice of motion made me wonder whether the SCA was not justified in its criticism on the issue of subsidiarity.
Justice Cheekley, we have been criticized by both the city and the province for the very general nature of the relief sought in the notice of motion. And we've got two submissions in response to that. The first is that in Metro Rail, the order that was granted by this court was in very general terms. That I'm speaking from memory now, and it's not entirely accurate, but it was to the effect that the SANRAL had not taken reasonable measures to address the issue of security in trains. It was in very broad terms. So we would submit that it's not impermissible to seek relief in broad and general terms. And the second submission is that if this court finds that there has been a constitutional breach on the part of the city and province, it's tried from the jurisprudence of this court that in the Mootness case, the court is not confined to granting a remedy in the terms sought by the applicants in their notice of motion. And the High Court, in the order that it granted, it was a more detailed order than that reflected in the simple declaratory order that was sought, that the province and the city had not taken reasonable steps to address the legacy of spatial apartheid in the centre of Cape Town.
Thanks. Another point, if you could just assist me, I know that you've referred us to Commando
Of the centre of Cape Town. But to come back to what lies at the heart of the case is that it's not in dispute that no social housing has been developed in or near the inner city of Cape Town. Now, Dr. Odendaal has provided a definition for purposes of assisting the court to determine the matter. That definition was accepted by the High Court in its order, and that is the definition, that is the best working definition that the applicants are able to place before the court for determining the merits of the matter. But the purpose of that definition was to give meaning to Mr. McCarthy's evidence about in or near the inner city. And our submission is that for purposes of the merits of the application, that is the appropriate standard to use, Dr. Odendaal's definition. If the court is minded to...
Mr. Hoffman, can you please try to shorten your responses?
I will attempt to do so, Acting Deputy Chief Justice. Can I just round off my response? But for purposes of a remedy, if this court were inclined to grant a structural interdict, we would be hard pressed to, if the government respondents felt that the definition, Dr. Oudendaal's definition, was inappropriate, and they, for purposes of their planning, they would prefer to work with another definition of Central Cape Town, then the applicants would be hard pressed to disagree with that. We would obviously need to see it in order to be able to comment on it, but it should at least include the CBD, Woodstock, Salt River, the Somerset precinct, where the province has said that it intends to make land available for social housing.
So should we assume, or should we take it that the province has ignored the factors in 5.1a?
Yes. They failed to give effect to them. We not necessarily ignored, but they failed to implement policies that have given effect to them. And also they've engaged in a course of action between 2010 and 2017, which has been actively retrogressive. They constitute retrogressive measures, and I'm sure Mr. Brickhill is going to address the court on the implications of that.
Okay. Lastly, is it a relevant factor that commando, the facts in commando were different? In the sense that in commando we're talking about people who were actually living in that area. Is it a factor that we should take into account at all when we look at commando and look at the facts of this matter?
The facts are, certain of the principles in commando in our submission are directly applicable. The facts and the nuances of the judgments, they're definitely important distinguishing features. And commando, the focus of commando is on temporary emergency accommodation. Here the focus is on social housing as one component of affordable housing.
Thank you. Thank you.
Thank you, Mr. Chief. Mr. Hoffman, I'm still on the social housing issue. And Paragraph 7 and 8 of the SCA judgment, the SCA criticized the High Court and says that he did not take into account the social housing pipeline. Okay. And it lists the number of property companies that have been developed by the city, and also the mention of the Somerset precinct. I know that in your notice of motion, Para 2 says that you can stop it correct that the city and the province have failed to comply with their obligations to redress spatial apartheid in Central Cape Town. I just need clarity. Which areas, in terms of the bridge that people are managing against the city, and the bridge that people are managing against the city and province, what has the province not done? And when, exactly where, if one has replied to the Para 47 and 48 of the SCA judgment?
Justice Nhlanhla, our starting point in responding to the reliance on the pipeline, and it's been a recurring theme in the submissions from the city and province throughout the various stages of the litigation, is that the Grootboom makes it clear that the obligation on the authorities is to take legislative and other measures. And mere legislation is not enough, but the formulation of a program or policy is the first stage. But that is not sufficient, that it also has to be implemented, but that is not sufficient, that it also has to be implemented reasonably, and an otherwise reasonable program that is not implemented reasonably will not constitute compliance with the state's obligations. And we would submit that this defeats respondents' reliance on programs that are in the pipeline, that it's not an answer to the case based on a failure of implementation to say, well, we've got programs in the pipeline, that the decisive consideration is that the authorities have had well over 20 years since 1994 to implement programs, and there's nothing to show for it. So that would be the first pillar of our response. Then, in addition, as the applicants point out in their application, the affidavit in support of the application for leave to appeal, there's a strong likelihood, or strong possibility, likelihood is overstating it, that many of those projects in the pipeline will never come to fruition, and that, as is apparent from the province's decision to release the Helen Barden and Woodstock Hospital sites in March 2017, they're taking ad hoc decisions in the absence of any coherent plan which is governing the pipeline. And then finally, that province is taking, their view is they'll take a long-term incremental approach and address the problem over many years. And as I submitted earlier, that is doomed to failure. That if one views it as a long-term project that will to be dealt with incrementally, then the available state land, which is necessary to deal with the problem, is going to be put to other uses, and it's going to be lost for possible uses for affordable housing after 5, 10, 15 years, whenever the province or the city gets to start looking at using those sites. And lastly, Justice Ndifuna, I'm not going to take the court through it, but if I can just commend to the court Mr. McCarthy's affidavit filed together with the replying affidavit. It's in volume 29 of the record, where he provides an analysis of the pipeline projects of both the city and the province, and he concludes that the programs that they've got in the pipeline are likely to have little impact because they generally relate to outlying areas and far from, not close to the inner city. And the city's projects, and he was deposing to his affidavit in August 2018, which was the city, I think, had filed the answering affidavit in August 20. Sorry, no, the city's answering affidavit was August 2018. I'm not sure of the date of Mr. McCarthy's affidavit, but the city's project, apart from the transitional housing site at Pickwick, their pipeline projects were at an embryonic stage, and appeared to have stalled at the stage of request for proposals. And we know from the applicant's replying affidavit that the main driver of the push to affordable housing close to the inner city within the city administration was Mr. Heron, who had resigned by the time the replying affidavits were signed.
I'm mindful that the Malawi police also want to ask questions, and maybe we can remind of what the ECG said is one of the responses. So from what you're saying, if one has regard to what is contained in paragraph 7 of the SA judgment, at line 24, where it says there was evidence to number of social housing issues, which really had 2,108 social housing units at a cost of 661. So that would be the only units that have been completed. The rest are still in the pipeline of planning stages. Nothing.
Implemented in or near the social housing projects have been implemented in or near the inner city, but she differs with him with regard to whether land has been released for purposes of potential for development, because Mr. McCarthy said it was just the Woodstock hospital site that the city had released land, and I think Ms. Gooch was focusing on the Helen Bowden and the the Helen Bowden site is in addition to that.
And the relief that we sought and part 2, this relates to what has not been done in the central city, which will include Seapoint with other areas. The central city, which will include Seapoint with other areas. That's basically what I can say.
Yes, our submission that the central city would need to include Seep, the Tafelberg property is situated, and also the Somerset precinct, which is where the Helen Bowden site is situated as well.
Now, what's your response to the city of the province when it says that choice city? It cannot do anything unless that particular area has been designated as a restructuring zone, because there's also an element of finding that has to be sought for the one to make proceed with the project.
The SCA judgment on the scope of the restructuring zones is not the subject of the extent of the restructuring zones is not on appeal. So that is the last word on it, but that has become moot to an extent because there has been, and I'm not sure if this is on the record, but I don't think it will be disputed by any of the parties. The regulation in which the restructuring zone was designated, which was the subject of the High Court and the SCA proceedings, has been overtaken by a new designation of a restructuring zone for the whole of Cape Town. So for remedy purposes, the whole of Cape Town is constituted as a restructuring zone.
Now my question relates to before the notice was issued, and having regard to what the SCA said insofar as the interpretation of the previous notice. If you mean that the Seapoint passage, I'm doing this in line with what you said that when we decided that it must be based on what was placed before the court, then not what the second instance was. Now my issue is, if we are also to accept that the SCA's interpretation on the out of the notice that the Seapoint was excluded. Now, if the city says we could not have done anything insofar as Seapoint is concerned because of the issue of
Justice Mhlanhla, for purpose the merits of the application, the situation as of May 2017 is determinative. So for the merits of the application, the restructuring zones as found by the SCA to be CBD, Woodstock, Observatory, and there was one other, I can't remember it. That is the final word on the subject. However, in Mazibuko, in the judgment dealing with the admissibility of evidence before this court, Justice O'Regan says there are two exceptions to the question as to whether further evidence can be admitted. This would be after the record for the High Court proceedings had been completed. And the first relates to evidence which would show that the government respondent was taking steps to progressively realize the right concerned. And the second would be whether evidence is relevant for purposes of remedy. So our submission would be that for purposes of crafting an appropriate remedy, if a remedy is to be given to the applicants, then the court would not be confined to the definition of restructuring zones as a 2017, but could take notice of the subsequent extension of the boundaries.
My last issues that we put before the court. The structure is all issues not on the table. We know that the conduct of saying has been cancelled. That's no longer on the table. So we left with the correct me if I'm wrong, the constitutionality of the relations 4146 and whether or not the province has to consult with the minister, national minister, before any decision is made, and then say there's a concession by the respondent that nothing has been done in the inner city, and so far the social housing projects. Is there anything else?
We're not party to the intergovernmental cooperation dispute. That's between Mr. Jamie and his client and the respondents. The question of Guiama is a live issue for purposes of our application, and also the question of the regulations, which Mr. Villiers will address.
Thank you.
This can be distinguished from the notion of social justice, because social justice is about the equitable distribution of socially valued goods and resources. That spatial justice is where they are located, and therefore one can't get away from space, as it were, in the debate about the spatial justice. And the Commando correctly accepts that the idea of spatial justice must be part of the understanding of adequate housing, as well as the concept of reasonableness that was developed by this court. My question to you is that it's possible that adequate housing could be given effective by a functionary who considers the question of spatial justice in the formulation of a particular project. Equally, not every project that seeks to advance adequate housing will give effect to the idea of spatial justice. And rising out of that may have to exist. So, in a particular situation, a functionary may say, well, our duty in terms of Section 26 is to ensure that the right to adequate housing is fulfilled. And in this instance, we've taken into account the dictates of spatial justice, But this particular project may not necessarily give effect to that particular idea of spatial justice, but without spatial justice being incorporated into that particular project. Because that goes to the heart of, in a sense, where the court sort of defers to functionaries. And perhaps the guidance this court may want to consider giving to the executive and perhaps to the legislature in how spatial justice is to infuse itself into mindful of those constraints.
Justice Colopin, I hope I'm not sidestepping the question, and if I am, I'm sure that I'm going to be caught short. But I'd like to start with the requirement in Grootboom that the plan that is formulated by government to give effect to socio-economic rights must be comprehensive and coordinated, and that a failure to have such a plan in place will constitute a failure to comply with constitutional and statutory obligations. And our submission is that it's clear on the papers that there is no comprehensive and coordinated plan to address spatial justice in the centre of Cape Town that is in place at the moment. With regard to your concern about deference, the relief that the applicants are seeking in our submission would give effect to the requirements of deference. What we submit should be the starting point in the formulation of a plan to address the issue should be an audit of all state land in central Cape Town. And then what should follow from that is that the city and the province should identify what part of that land it would be appropriate to be used for purposes of affordable housing or social housing. So that decision as to the extent of the land to be used would lie with the government departments. It's not something that the applicants can seek to dictate to, and we would submit would not be appropriate for the court to determine the extent of that. Then once that land has been identified, then it would be necessary to reserve all of the land that has been identified as being suitable for purposes of social housing to be implemented in accordance with a timetable and a program to be formulated by the government departments. And that could be an extremely long-term program. It could extend over 15, 10, 20 years. But as long as it's ensured that the land is reserved for affordable housing and it doesn't get lost for other purposes. And then it could be, the program could be implemented in accordance with the budgetary constraints that the city and the province labour under. And yeah, it would, in our submission, it would give effect to the requirement of, and I'm not sure if that deals with the issue of social justice as opposed to spatial justice, but
Thank you, it doesn't. All I just need to be clarity is that in the identification of that land process, we would accept that not all of the land identified would necessarily speak directly to the demands of spatial justice.
No.
That may be the inevitable outcome of such a process.
that's never been the applicant's case, Justice Colopin.
Before further justice Richard comes in, let me just get this out of the way. My sister Justice Rowan has questions for Ms. Dubilias. What I propose, colleagues, is that let us exhaust questions that to Mr. Concourt and will then invite questions for Ms.
Thank you, Mr. Chair. Mr. Hawthorne, I also have questions about this issue of spatial justice. But let me say just in passing before I deal with the question question about subsidiarity as well. I find it disappointing that none of the parties deemed it prudent to file a supplementary commando which came out during December last year. Even if you were remote, parties should have approached the court to ask for such permission, because I think commando, as you will glean from questions of my colleagues, has a profound impact on this case in the following sense. Throughout the judgment, the majority judgment of Concourt refers to social housing as opposed to, appears to accept, although that wasn't the central issue in the case, appears to accept that the city has provided adequately. In fact, the judgment says there's an imbalance between provision of social housing in the inner city and projects in the pipeline and emergency housing. So I would have thought that parties would have dealt with the judgment in supplementary submissions. Anyway, that is water under the bridge. Let me ask you, it deals with the question of subsidiarity. You say in your papers and in your submissions that you rely on a cluster of rights, as you call it, and therefore there is no single provision or provisions in enactments that enable you to challenge the legislation. Firstly, you could only resort to the Constitution. I don't really understand that in the light of provisions of SPLUMA and to a lesser extent of the Social Housing Act. Can you explain to me this cluster of rights argument?
Justice Majid, the cluster of rights consists of Section 25(5) of the Constitution, 26(1) and 2, and the legislation enacted to give effect to those rights. And the legislation which was the focus of the applicant's case was the Housing Act and the Social Housing Act. And given that the applicants state that at the core of the case lies the question of access to land, and Section 25(5), there hasn't been any legislation which comprehends the right of access to land. I think that the Provision of Assistance Act, it's Act 126 of 1993, it's an apartheid era statute which is used, to the best of my knowledge, primarily for purposes of rural land rather than urban land, would be the main statute that has been enacted to give effect to Section 25(5), and there's been substantial criticism of Section 20 of the Act 126 of 1993, the fact that it is apartheid era legislation, and although it has been amended, academic criticism is to the effect that it is incomplete and doesn't give effect to the rights of access to land. But given that there is a cluster of rights that are relied upon by the applicants, it's not clear which of the acts which have been enacted to give effect to the appropriate for the applicants to challenge if such a challenge was required. And Justice Majid, I submitted earlier, and I won't repeat it, but the fact that one provincial government and one municipal government has failed to implement and put in place appropriate policies cannot have the effect of amounting to a constitutional defect in national legislation, where it might well be that other provincial governments and other local governments across the country are implementing and acting on their obligations in terms of those statutes quite adequately.
Now, of course, there's an argument countering that says that you must challenge it under inclusivity of Section 25(5). But I want to move on to something else. The respondents, and the Western Cape respondents, also say in their submissions to the High Court. You didn't chat, your case wasn't Section 25, it wasn't access to that. It was a housing case. In other words, it was a Section 26 case. What do you say about it? It says you have now changed your stance. You've now made it a court case post-apartheid proceedings, and presumably post-SA proceedings.
Justice Majid, if one looks at the case as set out in the applicant's founding affidavits, Section 25.5 is relied upon in a very central manner together with 26.1 and 2. And it might be that we have focused more on Section 25.5 as it's not correct to say that it has never formed part of our case. It has always been a central plank of the applicant's challenge as is reflected in the founding papers.
You point me to the founding papers, and if you can't do so now, can you ask Olivia Junior to check for us and later in.
Justice Majid, if you give me a minute,
I see it in the notice of motion, but I want to check with you the founding affidavit itself. And as I say, you don't have to do so to move on to other questions, just to save time.
Justice Majid, if I be permitted just to... Justice Majid, if I can take the court to page 26 of the first volume of the record. And it's under the heading, the Constitutional and Legislative Framework. And the heading there is the Constitution. And then the very first paragraph that is relied upon is Section 25.5. And then
Sorry, where you go?
It's at paragraph 104 of the founding affidavit.
Yes. Let me take you to my major concern in your case. And it is this structural interdict, and I also have separation of powers concerns. As I understand your annexure A to your practice note, what you are asking for now, paragraph 5 and 6 of the High Court's order, which is at 3601, the hearing. Now, you say what you seek is firstly an audit of available state land, then what the land is to be used for in terms of plans and policies and programs, and then the land be reserved. And all of this requires the Western Cape government and civil state to report back to the court. Now, a constant refrain right through the papers of the Western Cape respondents is that they have this issue with the national minister that there is state land available in and around the inner city, but they've not had any joy from the national minister. This structural interdict requires of us to make these, I regard as far-reaching orders, venturing into the reign of executive policy making, housing policy making, without the national minister having been joined. Isn't that a serious flaw and potentially a total flaw in the ability?
Justice Majid, the National Minister of Human Settlements was joined as a party to the application, as was the Minister of Public Works in the High Court. They didn't oppose the relief, so then, although Mr. Jamie is here for the Minister of Human Settlement, the Minister of Human Settlements for purposes of their application. They were joined as parties to the application, but no relief was sought against them for the very simple reason that the applicants had made out no case against them that there was anything deficient with regard to the statutory and legislative framework and policy framework that were the domain of the national minister.
But once it became apparent in the answering papers that there was this issue with national land, should you have dealt with it in the headline and or amended your notice of motion to seek that relief also as it may affect the national minister? Because, I mean, these are wide-ranging orders that you seek. You basically seek an endorsement of the High Court order as varied in your Annex 8 your practice.
Justice Majid, there are two answers to that. The first is that the obligation to identify land for purposes of housing in terms of both the Housing Act and the Social Housing Act is an obligation that falls on the local government. So it is the city that is tasked with doing that, with identifying and sourcing land for purposes of housing. And if it has to liaise with other state departments in order to acquire that land, that's part of its responsibilities. And the second part of the answer is that after the SERI submissions were received, the SERI advanced the position that the national minister should be a party to any structural interdict that might be granted. The applicant's attorney wrote to the Minister of Human Settlements, the national minister, and asked her to furnish her counsel with instructions today as to whether the national minister would be prepared to participate and what role they envisage the department would play. In discussions with Mr. Jamie this morning, it appears that he's been unable to obtain instructions in this regard. But our submission would be that if the court is minded to grant a structural interdict, it has extremely broad powers in terms of section 172(1)(b) of the Constitution to grant any remedy that is just and equitable, and perhaps not to let me to preempt what Mr. Jamie is going to address.
We'll wait for that. And so there's also an argument last week on this structural interdict. It goes back to the questions I asked you in the beginning about your challenge. The city's case appears to be that, at least in the written submissions, that there was no constitutional breach identified yet, in the sense that your case concerns spatial justice and the reasonableness of a policy regarding social housing in the city. There's no breach, constitutional breach identified yet, and therefore a structural interdict is not appropriate, just an equitable relief, absent the breach of constitution. What do you say about that?
We say that the breach is twofold. Firstly, it's a failure to implement over a period of approximately 25 years, and it's common cause that there's no affordable housing in central Cape Town. So that would be the first component of the breach. And the second component is identified by the applicants in their replying affidavit after the city had given their evidence. It is pointed out by by Ms. Adonisi in the replying affidavit, the shortcomings in the policy framework that was in place at the time that the application was launched. And I referred to that in my earlier submissions and won't repeat it, but the inadequacy of the steps taken to identify land and the lack of the shortcomings in the pipeline, etc., and the absence of any inner city housing policy. So those would be the applicants rely on for in support of there being no reasonable policy in place in May 2017.
So what I want to raise with you the cluster of rights versus strategy versus and refer in particular to section 25.5, 26.1 and 2. The authority that you submit for this is Joseph versus the City of Johannesburg. That case dealt with the cluster of relationships, not rights, between the municipality and citizens. Looks like this is a new area that the applicants are going to, and it is what's the authority for that? And how was the property clause, I know it's a lot that I'm going to, how must the property clause, how must it be interpreted in relation to the meaning of equitable access and whether it does speak to realization of specific communities?
Justice Turan, you're testing my memory with regard to the exact formulation of the proposition in Joseph, but the court there endorsed the judgment in the Joe Slover case, and I think it might have been Justice Sachs's judgment in Joe Slover, where in the Joe Slover case one was dealing with the 26 again, but there was Justice Sachs of I'm not going to.
If you would prefer to do it.
Could I do that? I'd like to have. I'm worried that I'm going to misspeak and misconstrue the judgments.
Now, so on section 26.2, the obligation on the state is to take reasonable legislative and other measures within available resources. The province submits that what they've done is within available, having regard to available resources, the policy unreasonable. And if this court was to require the site to say that the site must be used for the realization of section 26, would it, in the context of such an incident?
Justice Turan, I'm going to try and have to be brief here because I've got a lot that I would like to say. Why is it unreasonable? The policy, the effective policy that was followed by province between 2012 and 2017 was effectively selling off the family silver. It was selling off prime, centrally located state land that, in our submission, would be indispensable for an effective, to effectively address the question of spatial injustice. And it constituted a retrogressive measure, and it required full justification, and I'm not going to try and steal Mr. Brickell's thunder. It submitted that there's absolutely no justification of the policy that was followed under the regeneration program. We're now told that the regeneration program was abandoned in March 2017, but we're not told what is in its place, and that would be the second leg of the unreasonableness. There's no explanation for the abandonment of the one policy and we're not told what policy is put in its place, if any. And you throw into the mix the lack of a comprehensive and coordinated plan to address the situation, and we submit that that is sufficient to find the requirements for relief.
Was the province not well within its mandate in excluding Tafelberg from the National Housing Program?
I can't argue with the SCA judgment, which is the last word on that point, is that the Sea Point wasn't in a restructuring zone in May 2017. Mr. Fagan's advice to the province has been vindicated. The submissions that we advanced have been shown to be incorrect. But Tafelberg was part of the regeneration program, and sorry. Well, it doesn't. It has no material impact on the failure to take measures or put policies in place to redress spatial injustice in central Cape Town.
Mr. Hawthorne, it's perhaps just to come back to questions that were raised by Justice Concourt. You turn to your paragraph 2 of the notice of motion. That's the character of constitutional rights. What you seek is one, that the respondents fail to comply with obligations to redress spatial context in the central Cape Town. I understand the arguments and understand the use of the terminology. Would it not be necessary for this court to find the respects in which it has failed to redress spatial context, and to be quite specific about in what manner it has failed, or they have failed to address the obligation?
Justice Wilson, when reading the formulation of the order in Commando, which deals with, if one has regard to Section 172, 1B, the 1A, the extent of the breach, it is detailed, it is spelt out in considerably more detail than it is in paragraph 2 of the notice of motion. In that regard, the principle established in the Ermelo case that if this court
Obligation to redress spatial apartheid. Obligation to redress spatial apartheid. The case is argued essentially on the basis that no affordable housing policy, or no affordable housing provision has been made in central Cape Town. Am I right that that's the failure to redress spatial apartheid?
that would be the first prong.
Yes.
The second prong would be the failure to have reasonable policies in place. And for the province, there's the regeneration program, which was abandoned and nothing was put in its place. And with the city, I referred earlier to the built environment performance plan, which deals with the point that they're in the process of developing in a city humans.
To what extent
Justice Goosen, my reading of those guiding principles is that they were broad general principles and wouldn't have given rise to specific obligations, but would have informed the manner in which the more concrete and detailed provisions in SPLUMA are to be interpreted. But we would in identifying the nature of the obligations, one would turn to Commando and the finding there, endorsing Bukhali to the extent that one has to read the Housing Act as imposing those obligations to redress spatial injustice. So that's we would rather locate the source of the obligation within the Housing Act following the Commando judgment.
One question I was going to ask it to Series Council, but perhaps I should raise it with you, since in your supplementary submissions you endorse Series' approach to progressive measures. It seems to me that the case in your founding fact in the High Court was put on the basis of simply assessing the reasonableness of states imposing.
I'm saying this apropos of the draft order that went on and on and on, but it let its end finally somewhere. And I think in 2014 there was the all-pay cash pay master measure. It's 11th year now, and we're still managing the structure. So I guess the short point I'm making is it's a very painful exercise for the court to manage the structural interdict. But of course, that if we must grant the structural interdict, the law demands that we should. But I just say it's painful. I don't expect you to comment on that.
I do have a comment, Acting Deputy Chief Justice, and if it's an antidote to the cases that you refer to, the first case that I was involved in, which entailed a structural interdict, was a matter of Rudolph versus the city of Cape Town. And it was a structural interdict granted by Justice Silikovitz in the early 2000s, and it concerned the provision of emergency housing in Valhalla Park. And the city filed their affidavits in accordance with the structural order granted by Justice Silikovitz. Our clients refiled our response, and we said we're happy that the city has addressed the problem, and that was the end of it. So,
Thank you so much.
Ask the court, please. Justice, the case in relation to unconstitutionality has got two components. The one is the ultra vires challenge on the line of affordable medicines and those line of cases, or ultra vires legality challenge. And simply put, the argument is that the Act, the Western Cape Land Administration Act, requires notice and comment in relation to a proposed disposal. And again, very simply put, the argument is that the regulations go further than that, or outside the bounds of that power in terms of the Western Cape Land Administration Act, and is therefore ultra vires. So that's the first component.
In what way do the regulations go?
So the regulations set out a detailed procedure in relation to disposal of land, and as I mentioned earlier, culminates in Cabinet deciding to approve the sale, and thereafter the MEC signs the contract of sale. What the regulations then do is craft a procedure which is not mentioned at all or specified in the Act, which is the ZILE, and as I referred to earlier, this deeming provision. So effectively saying in the contract of sale has been concluded, all the terms have been decided, but what province can do, well, firstly, it shall be a proposed disposal, and as I said earlier, as Seri referred to in their submissions, effectively it's a deeming provision. It's saying, yes, your transaction is concluded, you've signed your contract of sale, it's all done, but we're going to deem that to be a proposed disposal. In other words, it's not a disposal. So that's in our heads of argument. We refer to the case of Afri-Business of this court, where the principles are nicely set out, a matter dealing with vires. And essentially our argument using those principles is that the regulations in effect change or do not accord with the ordinary grammatical meaning of the words proposed disposal in the Western Cape Land Administration Act. And in a sense, the regs go further. They create this new mechanism, which is notice and comment after the transaction has already taken place, subject to this right to resile.
What approach is jurisdiction applied to allow for public participation? And I assume your argument would be sufficient to have been before a decision was made to dispose of practically, however.
Justice, if I can address that in two aspects, perhaps start with something to say notionally what could have happened, and again I just use Tafelberg as an easy example, is one could have a tender process. So province decides we're going to sell this property, there's a tender process, tenders are in, and so all the offers are there. When one looks again at that submission to Cabinet in November 2015, notionally at that point there could have been notice and comment. So then before Cabinet, one would have notice and comment, all the comments have come in, the department would have assessed those comments, and the Cabinet would then have before it, yes, I think there were 3 that were responsive, and what the public has to say is the following, and the public may, for example, in that case, some people may have said, no, sale shouldn't go ahead, that property should be used for social housing. Others may have said, no, it's an excellent deal for province, 135 million rand, go ahead, and so forth. So that Cabinet then takes the decision once. Not, we're now going to approve this sale, the MEC is going to sign it, and then in due course, we might come back and decide, sorry, we're not going to go ahead anymore. So just going back to practically, that would be an option. And that may address some of the issues that province has raised, and also that the SCA pointed out that one has then a proposed transaction that one can then comment on. What we say, though, is that in order to provide meaningful public participation, that at an early stage would best give effect to that. And again, the practical example I mentioned earlier of the municipal asset transfer regulations, where there's an early decision. But these are things I think that province could grapple with if the court was so minded to declare the reg unconstitutional. It may be that one has of sale, It may be that one has different procedures, maybe there are various ways to cater for which would be the best stage, and maybe that's done, as I said, in relation to different transactions, different types of transactions. Minded that it must be practical. But again, as I said, at the very least, one cabinet decision with public participation before that.
Thank you, Ms.
Acting Deputy Chief Justice, Justices of the Constitutional Court. I'm going to address three aspects. The first, well, I'm going to begin by just brief introductory remarks, and the first substantive issue I'm going to deal with is that of mootness, which is raised by the province. The court will be aware by now that the lists between ourselves, being the National Minister of the City, well, let me immediately qualify that. The original list no longer exists. There appears between, well, saying list is perhaps at a level which it isn't at, but the potential involvement of the National Minister in any structural interdict that this court might be minded to grant has been raised most pertinently in Baseri, and I'm not going to address that squarely in my 30 minutes, because I believe I'm entitled to address it once Seri makes the argument, depending on the argument they make, and obviously on the argument of the respondents in answer, and we do have a position of the National Minister apropos that. So I'm not going to address that. So I'll address mootness, then I'm going to address the two substantive leave on, and that is Guillaume and Igfra, and I'm going to deal with Igfra first and then Guillaume. With those opening remarks, Justices, let me then begin. The constitutional context we submit of this case is twofold. The first aspect, first focus, constitutional issue, is the obligation on organs of state, and in this case, to act cooperatively with each other as enjoined by Chapter 3 of the Constitution, which has been given effect by the Bible. So that's the one constitutional backdrop. The other is the particular rights which are raised in this matter, and in that regard, we say the right that is raised in this case is the obligation of the state, cumulatively, as indicated originally in Krobum and thereafter in many cases, to take reasonable legislative and other measures within available resources to achieve the progressive realization of the right, as I say in this case, of access to adequate housing. And that right is to be found obviously in section 26.2. Now we, Justices, say that Seri adds a valuable component to the debate with its submissions as to the prohibition on the taking deliberately by the state of retrogressive measures. And that's a notion, as we know, as they point out in Krobum. And obviously we accept as the National Minister that must be correct. As the Court knows, we seek leave to appeal against the whole of the order of the SCA, Justices. And insofar as it concerns the actual High Court, well, the order of the High Court, which you find at volume 13, in the Minister's case, volume 13, thank you, pages 1304 to 1305, the substantive order that we seek, as we point out in our heads, is the reinstatement, if you're with us, if leave to appeal is granted and you then uphold the appeal, Justices, we seek reinstatement of the order granted by the High Court, which you find at volume 13, page 1304. and that is the declaratory order in respect of the failure we submit on the part of the national government to the provincial government to inform and consult the national government apropos the disposal of the Tafelberg property. It occurred to us while preparing the argument that if you're with us on the Guillaume point, the effective and substantive relief that we would require just in paragraph 4 of the High Court order, because obviously paragraph 1 is limited to the issue of failure to inform and consult, so that wouldn't form a basis for an upholding of the argument in respect of Guillaume. So we would say that if you're with us in respect of Guillaume, the appropriate order for this court would be reinstatement of the High Court order with the last 5 words deleted, because it no longer needs to be set aside because of the passage of time, as you know. So accordingly, we would simply then ask the court for the declarator that the High Court originally granted, declaring the sale to be void and of no force in effect, and that would be, if you're with us, for want of compliance with Guillaume. Because of the passage of time, obviously, 2 and 3 of the High Court, paras 2 and 3 of the High Court order are no longer appropriate, and we don't seek that. So that would be the relief that we would seek. The province justices, so as I said, there's no list between us and the city any longer, and I don't then understand that the city opposes our application for leave to appeal on the issues that we raise. But we'll hear from the city, no doubt. But the province certainly does oppose our application. It does so inter alia on the basis that the application seeks to raise issues that are moot. We submit that this is not the case. We've dealt comprehensively with mootness in our heads of argument at paragraphs 18 to 27. I'm not going to take the court through that, but I'm simply going to emphasize the following points. Although the Tafelberg sale has fallen through, the future use and possible and this is on the papers, justices. The future use and possible disposal of the property remains a hotly contested issue. It's clear that fundamentally different views as to the legal requirements of any future conduct in respect of Tafelberg. As this falls, the disposal, or whatever it does with Tafelberg, falls within its exclusive competence, and thus it is not required to inform, let alone consult with the national minister. It's stated that view fairly vigorously in the correspondence that forms part of the record, and it in fact challenged the minister to explain on what basis she wished to be involved, consulted, or informed. The minister takes a fundamentally different position. The minister's position is that the province's position from the outset is fundamentally misconceived. The obligations imposed by Chapter 3, and in particular by IGFRA, which is my shorthand for the Intergovernmental Relations Framework Act. The only way one can easily say that is IGFRA, as opposed to putting the R first. And I'm not going to take the court to that at this point to any extent, but can I just ask the court in this regard to just focus on Section 5A of IGFRA, which requires governments to take into account the material interests and budgets of other governments and organs of state in other governments, and then the important words, when exercising their statutory powers or performing their statutory functions. Now, this debate we've dealt with it in our heads extensively. It formed the fundamental basis of the debate in the Court Arquo and in the SCA. The minister's position has never been, despite misconstructions to this effect by the province, has never been that, and with great respect, the SCA considered a matter which had never been the minister's case. The minister never said Guillaume was the source of the power of the province to dispose. The minister's case was always that we accept the province had the power to dispose. We simply said it affected the material interests of the national minister and the national government, that disposal. And thus we had to be informed of that disposal, as opposed to all disposals or any disposal. And that is what triggered the obligation to inform and consult, which is sourced in Chapter 3 and then given effect to in Section 5. So there's a fundamental dissonance between the parties in that regard. And then obviously the parties also differ as to Guillaume, and you have that difference in the heads, justices. The province's position in opposing our application for leave was that were this court to agree with us, it would render all disposals of national and provincial land invalid. We say that's not the case because, as you pointed out, Acting Deputy Chief Justice, any order of this court, a declarative is one thing, that is peremptory and must be, you find, something to be unconstitutional and unlawful in terms of 172.1a, but there is 172.1b, which allows you to make any other orders. So this court has dealt with that very often. No one would suggest it would be, if you were to be with us on Guillaume and were to then give a judgment which deals with that, that would be a prospective judgment. Or you could make it prospective, and we would certainly suggest it should be. Because, as you know, there's a dearth of jurisprudence on Guillaume. In fact, we've been unable to find any other cases except for the two that are preceding this one. So, for all those reasons, we quote in our heads as AfriForum justices and also Pillar, and we submitted conspectus of all those principles and the facts. The matter is not moot, but if it is moot, then on the basis of the considerations in Pillar, leave, or the court should entertain the matter. With regard to leave to appeal, we say we satisfy the requirements both of 1673, or both of the requirements in 1673, namely that the case raises constitutional issues and an arguable point of law ones I've articulated in the context of mootness, and further that it is in the interest of justice for this court to hear the appeal, especially in light of prospects of success. We submit it is particularly important for this court to hear the appeal and grant its leave and hear the appeal, justices, because of the difference in judgments, the fundamentally different positions taken up by the High Court and the SCA, and that's one of the considerations this court will take into account when considering whether to grant leave to appeal, different judgments, conflicting judgments, which there are. And the other consideration is the fact that, with the greatest respect to it, the SCA judgment cannot be the final word on Guillaume. It is only the second court judgment on Guillaume, as I say, but it is, with the greatest respect, wrong, and it is fundamentally important that this court correct that. And we're fully aware that you're not allowed to, and you don't, appeal against reasons, you appeal against orders, we are aware of that. But that being said, the SCA is the second highest court in this country. Its reasoning will obviously be persuasive and, in fact, effectively on similar facts binding on other courts. And it got Guillaume wrong with the greatest respect, and this court, it can't be left like that. So this court should correct it, and this court's victor in its judgment, if you're with us, on Guillaume will then be the correct word on the topic. Guillaume's important legislation, central legislation, as we point out, and it is imperative and it is a basis to give us leave to appeal that the SCA's judgment on Guillaume is corrected. Although my second last submission on leave to appeal is that although it goes to the facts, the SCA, with respect to it, got it fundamentally wrong on the intergovernmental point and the duty to inform and consult. It conflated the duty to inform, which is not to be found in Section 5b, and in the passage in this judgment where it quotes, refers to 5b in relation to the notification in terms of the Western Cape Land Administration Act as sufficing to inform the National Minister, it conflates the position justices and yes, so for all those reasons we submit that leave to appeal should be granted. Going on to then the IGFRA points, the Minister's case was squarely pleaded on the basis that there was a failure to inform and consult it with regard to the disposal of the Tafelberg property. The duty to inform is in sections 41(1)(h)(3) of the Constitution and section 5b are two those. We plead that expressly at paragraph 17 of the founding affidavit, volume 1, page 16 of the record. The Minister's first letter to the Premier referred to her views regarding the development of social housing on the site. So that issue was raised pertinently. You find that in volume 2 at page 126. Response was in effect to say that the disposal fall within, as I've indicated to you,
Ask you when we come back, please hold the floor.
I'm sorry, Justice. Oh.
We will take it to your agenda.
Oh, I see.
So we will take one or two steps to repeat the point you are making now and then go forward when we come back. And because I started speaking before the clock was paused, I will give you an extra minute.
I'm gratified, Deputy Chief Justice. Thank you.
don't start the clock. Mr. Jamie, the colleagues sitting to the far left and far right say that we can't hear you. Can you perhaps either give your mic and perhaps even your voice just to make sure?
I've had many complaints in this court, acting Deputy Chief Justice, not that one before. But I'll seek to remedy. I'll seek to remedy that as the court pleases. Yes, Justice. B. Consulting other affected organs of state in accordance with formal procedures as determined by any applicable legislation or accepted convention, was agreed with them, or in the absence of formal procedures, consulting them in a manner best suited to the circumstances, including by way of direct contact or any relevant intergovernmental structures.
Thanks a lot for that clarification.
As the court pleases. As the court pleases, I was saying that the Minister's letter to the Premier indicated her views regarding the development of social housing on the Tafelberg site. That's at volume 2, page 126. The Premier's response was in effect to say that the disposal fell within the provincial government's exclusive competence. You'll find that at volume 2, page 138. I've already dealt with why that is not a sustainable response. We've referred in our heads, Justices, at paras 126 to 128 to the relevant jurisprudence of this court. We make the point in our heads that the Supreme Court of Appeal judgment refers to no authority whatsoever in dealing with the IGFRA point. We've referred to the relevant jurisprudence. In essence, and just to emphasize, in Eskom Holdings, this court said that the purpose of requiring cooperation between spheres of government was to address the legacies, was inter alia, to address the legacies of apartheid and discrimination, and we reference that quote at para 131 of our heads. In Grootboom, the court identified 6 requirements, Justices, which are relevant and which speak to the interrelationship between spheres of government, specifically in relation to the reasonable implementation of a housing program and the vindication of the Section 26 right, progressively. And I'd like to, it's to be found at Grootboom in paras 39 to 40, and they are the following. The court says what constitutes reasonable legislative and other measures must be determined in light of the fact that the Constitution, 1, creates different spheres of government, national, provincial and local. 2, the Constitution allocates powers and functions among these different spheres, emphasizing the obligation to cooperate with one another in carrying out their constitutional tasks. 3, apropos a program to do so, a reasonable program therefore must clearly allocate responsibilities and tasks to the different spheres of government and ensure that the appropriate financial and human resources are available. 4, in parent housing program must be a comprehensive one determined by all 3 spheres of government in consultation with each other as contemplated by Chapter 3 of the Constitution. 4, the national sphere of government must assume responsibility for ensuring that laws, policies, programs and strategies are adequate to meet the state's Section 26 obligations. I'm going to come back to that because it will address perhaps preemptively what we expect to be advanced about the Minister's involvement in any structural interdict. And finally, the 6th requirement or principle, it must be emphasized that national government bears an important responsibility in relation to the allocation of national revenue to the provinces and local government on an equitable basis. Furthermore, national and provincial government must ensure that executive obligations imposed by the housing legislation are met. Now that we submit is the constitutional context which is entirely lacking from the SCA judgment and from the provinces. We've already indicated the province's position is this was our power, exclusive power, you're not involved, we don't have to speak to you, they're wrong. for those reasons. It's a cooperative, collaborative thing. It cannot be done in isolation as they sought to do in this case. The National Minister had an obvious interest in this matter. Our case was never, the SCA makes much, or labelled my clarification in that court as a concession. It was not a concession. It was a clarification of our case as pleaded from the outset. Our case, the National Minister's case, was never that we needed to be, or that the Constitution required us to be consulted when the provincial government disposes of a house of no moment to anyone in Goodwood or wherever else in Cape Town. That would be an absurd proposition. We did not make that case. Our position always was, informed by the provisions of the Constitution and ICFRA that we've referred you to, is that where a disposal implicates a material interest of the national government, or where it affects common interests, as explained in the or as provided for in the Constitution and ICFRA, that is when we must be informed and consulted. This, on any approach, this disposal, Tafelberg, obviously affected the National Minister's interests. We've dealt in detail with that in our heads. I'm not going to take you through it again. Brief summary. This was one of the few, for those justices who are familiar with Cape Town, one of the few, if not only, state-owned properties in the middle of Sea Point. Sea Point is a particular area, lots of working class people, lots of people who work for wealthy people in Sea Point, no accommodation for workers, lots of schools where children of poor families go. It was the subject of extensive debate, this disposal, as you know. It was the subject of litigation, the initial litigation by NU. It then went out to consideration. Again, there were thousands of responses. The national government the provincial government had to follow a special process in order to enable it to properly consider the responses. And finally, unlike the disposal of an ordinary provincial property in Goodwood, here Cabinet not only considered the matter once, it considered the matter twice. So, and then lastly, and perhaps most directly, national government via its agency, SHRA, who was a respondent in this matter, was an applicant, co-applicant initially, and then also via one of the social housing institutions, NASHO, expended money on this very property. So for all those reasons, Justices, this was a matter that implicated the National Minister's interests. It's a matter of common interest, and that's why we had to be consulted and informed. And we've set out in our affidavits and our heads in detail this. We're not just raising this as some point in order to take a point against the province. We've told the court and the province what we would have told them. And apropos one aspect, perhaps, I can just deal with it now. Justice Shiki, I think, raised the question of the restructuring zone. My learned friend, it was Justice Mashlantla who raised the question of the restructuring zone, Justice. And I think correctly, Mr. Hawthorne for NU had to concede that the SAA's word on that topic, namely that Sea Point doesn't fall within the restructuring zone, is the last word on the topic. That might be so, but before the SCA made its findings in that regard, we've said in terms in our papers and in our heads, and the deponent for Schra says this in terms, that restructuring zones were never intended to be an impediment to the development of social housing. They were intended to assist if there's a restructuring zone, national funding is triggered. It was never intended to be an impediment. It would be perverse. That would be precisely what Mr. Brickhill argues, a retrogressive measure. But had that been a genuine concern of the province, it was quintessentially the sort of issue they should have raised with us. There is there's a regularly used forum, MINMEC, referred to in the papers in our heads, which could and would have addressed that. It was a simple matter for province, for the municipality to say, we want Sea Point to be a restructuring zone. We know that's now happened. So that was not a real impediment. That is a chimera which province sets up abilities. It can't do that. Had that been a genuine concern to it, It should have raised it with us. That's precisely why we should have been informed and consulted. We would have told them, but excuse me, why are you making this an issue? Raise it at MINMAC. We'll amend the restructuring zone. So that's with respect to the answer to that. That emphasizes why we should have been consulted and why Grootboom should have been applied in this case, and not the problems go it alone approach. Given the time, those are our submissions on ICFRA. With regard to Guiana Justices, we submit, and again I'm not going to repeat, our submissions in the heads we've dealt with in detail. As I've said, there's a fundamentally different approach to Guiana. The SCA, with the greatest of those respects, misdirected itself in its understanding of Guiana. I want to focus just on two aspects which are central, we submit, to the Guiana issue. The first is the role of CAMPs and UAMPs. And we submit that the whole purpose, and we differ obviously fundamentally from the province's submission that this was simply meant, if we understand the argument correctly, as some sort of internal audit check for financial and budgeting purposes. It clearly isn't. We've referred to the provision in Guiana that said, the provisions that inter alia say that a UAMP in the case binds the user in the exercise of its executive authority. Nothing could be further from an internal budgeting process. We've also referred to the fact that I think it's section 6.2 provides, could be 4.2 in the heads, provides that in the event of any dispute between a user and the custodian, it must, in fact, that's an interesting provision. Section says, in the case of a dispute between a user and the custodian, that dispute must be resolved in terms of ICFRA, which is not only meant to be given effect to, but in fact envisages intergovernmental disputes that have to be resolved. It's not an internal auditing, checklisting as province would have it. There's also the provisions that the UAMPs and CAMPs must be submitted to the relevant treasury, and finally the provision that non-compliance with provisions of the Guiana is criminalised at the instance of the accounting officer. All of that deals, we submit, or provides us a complete answer to the province's arguments in this regard. And one of the glaring, we submit, weaknesses in the SCA judgment is that it never explains. Firstly, it seeks to characterize, it says, rhetorically perhaps, why couldn't the details of the regeneration program be the CAMP and the UAMP? It can't, because that's not what's envisaged. What's envisaged are the actual documents that have to be lodged with the Treasury, program with the Treasury. So more importantly, and I think you raised the question, Justice Shiki, as we in relation to the structural interdict, which we are not directly involved in, and 5.1f. You said, as I understood the question, we submit that what 5.1f says and requires in terms is that in relation to a disposal, the custodian must consider whether the immovable asset concerned can be used by another user or jointly by different users in relation to social development initiatives of government, and 3, in relation to government socio-economic objectives, including land reform, black economic empowerment, alleviation of poverty, job creation, and the redistribution of wealth. Those are all obviously essential government objectives and aims. They cut across all levels of government. We've quoted the authorities that say such persistent problems are rest. Can I go to 52 as the court pleases? Thank you. Those persistent problems are best addressed, and there's ample jurisprudence, we've referred to it, and this is what the Constitution requires, precisely. Governments are not required under the Constitution to cooperate, etc., with each other just because it would be nice to do so. It's a purposive mandate and instruction. They must do so because that is the way that you best address the legacies of apartheid, discrimination, undo the past, and achieve progress. That is expressly what Grootboom says, multitude of other cases from this court says. That is the only way one can, with constitutional understanding that one must apply 39.2 when interpret any legislation, that is the only constitutionally compliant way to interpret that section. That when in Roman 1 it refers to use by another user or jointly by different users, that is not confined only to users within that government. It can refer and does refer. So we submit our interpretation, then I rest, as the court pleases.
On the last point, Mr. Jenny, I was wondering when I reflecting on this, whether again is required
Yes.
once it has decided on the disposal to just mirror consult with everybody that it thinks may have an interest in the properties, or can be a potential user, or whether you're making this submission in relation to the fact that the minister in this letter will lifted his hand and expressed an interest. So I say that as a general principle, there should be consultation with anyone who might have an interest, or should the custodian wait until there is an interest shown?
Justice Shiki, what our submission would be that one doesn't expect the impossible or unreasonable from any officials. So the custodian here would have to act rationally. That would be the minimum standard, and legally. Rationality would require that the custodian must apply his or her mind to what the known facts are. And if the known facts are, as in this case they were, for instance, that Human Settlements Department had not only evinced a desire for the property, they'd formally responded and said, we want the property, we can use it, and we will use it. What the custodian then would not have been able to do on a proper construction of 51F is to do what happened in this case, which is they bullied. So the SCA says the department grudgingly withdrew human settlements. That's a misdescription. They were bullied into not persisting with their clearly articulated and evinced intention to develop that property. They were clearly therefore a user. And on the facts of this case, on a proper construction of the section, what should have happened is, if there was an ongoing dispute and disagreement between the two, it should have gone via the IGFRA route. It didn't, precisely because there weren't CAMPs and UAMPs, which demonstrate the point that this entire disposal of Tafelberg happened in a manner which elided the legal requirements. But that is my answer on the specifics of this issue, of this case, of this disposal. On the more general proposition you put to me, Justice Shiki, the answer would be that, as I've said, the impossible is not required, the unreasonable is not required. So what the custodian must do, the custodian must have a CAMP which deals entirely with disposal. And whether, as I say, again, depending on what the disposal is, it's not for me or the court to say what the content of that CAMP must be. But perhaps it would have different types of properties, different tiers, as you have with monuments. And a certain tier will, if they wanted to sell the castle, for instance, clearly that would implicate a national interest, but not the house in Goodwood. So for something that is like or wider interest, they must send out notices, whatever they must do, in terms of that CAMP. All of that could be tested if it ever were disputed in a court of law. It would have to pass, we submit the test of rationality, but none of that happened here, and therefore we're debating in vacuo.
Well, I was asking that question because there's reference, I think one of your opponents refers to a need, for instance. I mean, we know that there was
Sorry, refers to?
I'm saying that I was asking that because I can't remember which party, but was making a reference to the fact that it could be needed for a school, for instance, not necessarily for human settlements, but I mean, you've answered me. Let me refer to 51A.
51A.
Yes. I wish to understand the reference to surplus.
To surplus.
Yes, and because there it is said that an immovable support is service delivery objectives. Service delivery objectives, is it only limited to issues like housing and all of that? Or could a user then say, well, I want to sell it so that I can generate enough money in order to make sure that the service delivery. So I want to understand what the meaning of surplus is. Surplus, then it should, the purpose should just be on socio-economic rights only and specific socio-economic rights.
That's the original sin at the heart of this disposal. Because human settlements said, yes, we can use it, we want to use it, inter alia for social housing. We think it's very suited for social housing. But we know from the facts primarily in NU that Mr. Carlyle, who was the MEC at the time for Public Works, did not want that. He is the author of the remark, no RDP in C points. So he was opposed to it. And through a quite murky factual situation, it then comes to where DTPW leans on human settlements to get it to withdraw its clear indication that it wanted to use the property. And we know what happened there. But before DTPW, and the reason, by the way, that it leaned on human settlements was it could not dispose of the property to the outside world without that withdrawal of interest by human settlements, because a user, and it's important the court has an understanding of this, the definition of user is not only a government department that is actually using an occupation of an immovable asset. If you look at the definition of user, it is a national or provincial government that uses or intends to use an immovable asset in support of its service delivery objectives. So here, on a plain reading of Guillaume, human settlements, once it made its intentions and desires known in respect of Tafelberg, was a user. And thus, the custodian of the property, DTPW, could not dispose of it while that user status remained. Hence, it needed to lean on human settlements in the province to get them to withdraw. So, I don't know whether I've answered the question, but as the court is. Sorry, Justice, can I just, Justice Rogers, can I just make it clear? I never suggested, and if you understood me to be saying that, I've never suggested the National Minister was ever a user in respect to this property.
Well,
I was talking about...
I understood the argument to be that the user can include the national government. I'm not sure, not necessarily the National Minister, I'm not sure if you include the Social Housing Agency as an entity in the national sphere, but I understood your submissions to focus on the wide meaning of government and the use of the plurals, and therefore national government could be regarded as a user.
In respect of provincial property.
The property was in the custodianship of the provincial government. Is that your argument?
At a principial level, yes.
Independently of hearing the party's submissions, I thought it was pretty obvious that it's provincial or national government, depending on whether the property is vested in national government. the implications of your submission would be, for example, that the custodian would have to submit its custodian management plan to the provincial treasury for approval. You can say, well, the national government became a user, and a different treasury, national treasury, would have to approve the national government's user plan.
No, I think, no, Justice. Argument is focused on 51F and a proper interpretation of 51F. I've made the submission, and there is a tension between my submission and the definition of surplus, certainly, but if I could just ask the court to...
I just want to know, if you did not argue that you can simultaneously be a user at national level and a custodian at provincial level, then my questions will fall away. I understood your submissions to say precisely that the user in relation to properties of which the province is the custodian can be in the national sphere of government.
Yes, I did make that submission, but it doesn't flow from that with respect that the province's CAP, which must be prepared by DTPW in the province, must be submitted to National Treasury.
That's not what I said. I said the implication of your argument would then be that the custodian plan would have to go to provincial treasury and the user plan would have to go to national treasury.
But there wouldn't be a user plan. Which user plan?
If the national government is a permissible user in relation to a property that vests in a provincial custodian, then the user plan would have to go to the relevant treasury. Is the relevant treasury in relation to national government and national treasury?
It would be, Justice, but I now understand what you're putting to me. You're putting to me the possibility that the same property could at one and the same time be the subject of a custodian plan prepared in the Western Cape, submitted to the provincial treasury, and be the subject of a user plan prepared by the national department, submitted to the national treasury. There is no dissonance, with the greatest respect. There's no dissonance. That's the way Guillaume works. The fact that they deal...
So the two treasuries would be involved. Now, I appreciate the guidelines which provincial and national governments must comply with can't be used to interpret the Act. But when I read them, they would give rise to remarkable consequences if your argument were right. Those guidelines, at least will appear in volume 10, starting from the beginning. But if one looks at 939, under key principles, item 8 is the user and the custodian must jointly ensure that immovable assets match the service delivery strategies of the user. That would mean the provincial department must jointly with the national department ensure that the province's assets match the service delivery strategies of national government.
With respect, you've made... The first point would be you cannot use the guidelines, justices, to interpret Guillaume. The second point would be that would not be insurmountable. It may be impractical or difficult, but it certainly would not be insurmountable to comply with that, if I understand. I don't have that before me.
Under item 18 of the guidelines, the effect would be that the province would have to assist national government to compile the user management plan. And under the same item 18b, the accounting officer of the custodian, that would be the provincial...
Sorry, Justice Rogers, the volume has just been handed to me.
Volume 10, page 940.
40.
The provincial department must assist
Yes.
a national user in the compilation of the national user's management plan. And the provincial custodian must consolidate and assess the national government's needs in terms of, this is now presumably the province's asset portfolio by means of options and assets. It just seems, I could go on, there are other provisions
So,
of similar effect, but it seems to me a complete, give rise to a complete disjuncture to have users and custodians at different levels of government.
With great respect to Justice Rogers, there are two answers to that. The first is, given not the paucity, the dearth of judicial interpretation of Guyana, that document has been prepared by civil servants. And if they got it wrong, it's clearly been prepared on the basis, Justice, which will cover 95% of cases, that a custodian and a user are always within the same government. I fully accept that, but that is of no relevance to the interpretation of Guyana. That's my first response. My second response is the following. On the basis of what you're putting to me, if you read them disjunctively, then, and there is no, with the greatest respect, Justice Rogers, if you look at 5.1f, in relation to a disposal, the custodian must consider whether the immovable asset concerned can be used by another user or jointly by different users. Now, given that a user, I've taken you already to the definition, includes a government department that can use the asset or intends to use the asset, and I accept that National couldn't just parachute itself in and say, I demand to use that asset. It must, again, follow some intergovernmental process. But it evinces a desire to use the asset which is reasonable and rational. The province is prepared to entertain it. There is no basis on a textual approach to the words by another user or jointly by different users to read that as being confined to a custodian must consider, to read it as if it says by another user or jointly by different users within its government. It doesn't have those words. I'm terribly sorry to be so at odds with you, Justice Rogers. I'm sorry, to what?
I'm inviting your consideration to the proposition that may be a more natural and constitutionally compliant way of identifying the interest of another sphere of government in relation to property currently owned same property.
With respect, Justice Rogers, my response to that would be that evinces an appropriate understanding on the part of the drafters of the guidelines that in order to give effect to government objectives, it might be appropriate in the circumstances of any particular case to transfer property owned at one level of government to another level of government in order for it to carry out whatever its service delivery objectives are. That would give, with the greatest of respect, that would give effect to the overarching Chapter 3 obligation to support each other and to be complementary, with an E, toward each other's efforts, and to act in a manner which government can best achieve by acting together, as the cases say. And that is also, if I could just finish the submission, Justice, that is also the reason that we press for our interpretation of 5.1f, because to read it as in a silo manner, that it's only your own government, because that'll trickle through, that will affect not only Roman 1, the reference to user, but also the others, because if you're only looking at your user within your bailiwick, you're not considering how those objectives can be achieved best, constitutionally compliant or consonant, and it certainly doesn't best achieve the objects, those objects, which lie at the heartland of the constitutional project.
That's why the distinction I'm drawing might ultimately be thought to be a technical one, because the way national government feature in a setting like the present is not as a potential user in relation to the provinces, but as a potential recipient of a disposal of the property as one of the province might consider.
No, I mean, that clearly is possible in terms of the guidelines, Justice.
Thank you, Mr. Davey. Mr. Quickly.
Mr. Court, please.
Acting Deputy Chief Justice and Justices. This matter concerns broad issues relating to the provision of affordable housing in central Cape Town, but also the amicus curiae has identified two sets of bedrock constitutional principles which we submit cut across the issues that are in contention between the principal parties. The first is the substantive principle of non-retrogression, and a set of procedural principles relating to participation rights in the context of socioeconomic rights. I emphasize that in relation to the procedural rights, and I won't have an opportunity to develop those submissions, we make the submission that there must be participation in the context of this type of disposal of unhoused or precarious communities who have the most at stake when public housing stock is being sold. And secondly, where there are actual occupiers of such a property, the process needs to go beyond notice and comment to include meaningful engagement with those occupiers before a decision to sell is taken. We apply those two sets of principles, the non-retrogression and participation principles, to the four contentious issues which Justice Mhlantla also identified and clarified as the issues at the heart of this case. The question of the spatial justice relief, Guiama, the duty to consult national government, and the constitutionality of the WCLAA regulations. We don't have an opportunity to address all of those issues. We focus on just two questions in our oral submissions. The first is the doctrine of non-retrogression and its application here. And secondly, what that means for the spatial justice relief sought by the applicants. On the question of non-retrogression, Justice Madlaga, I'm not sure if there's a difficulty with the clock, but it did seem to move rather quickly down to. Perhaps it's just me. Perhaps it's just me. We, of course, invite and are available to clarify in response to questions, anything that we don't get the opportunity to address. We stand by our written submissions. On non-retrogression, Justice Rogers asked the question, has it been pleaded? and does it apply on the facts? There are really two questions. We submit that the proper approach to whether this court can consider the non-retrogression issue is provided in this court's judgment in KwaZulu-Natal Joint Liaison Committee, the majority decision of Justice Cameron. In that matter, the principal applicants, the matter concerned school subsidies and a cut to school subsidies. The principal applicants relied on contract, and amicus curiae, the Centre for Child Law, introduced a public law cause of action, and the majority of this court ultimately decided the matter on the basis of a similar public law cause of action, not exactly as the amicus had argued. But the key principles from that judgment are that, provided that there's no prejudice to the principal parties, new legal points can be raised. And indeed, it's an appropriate role for an amicus curiae, we would submit, which is required to introduce new issues, provided, of course, that there is no prejudice to principal parties. We submit that there is no prejudice in this instance because province and the city always knew that the case that they had to meet was to justify the sale of the Tafelberg properties, and more broadly to justify their policy approach. That was always the case that they had to meet, relatedly, both parties have declined the opportunity to respond to the amicus curiae's submissions in the form of filing supplementary submissions of their own, which this court allowed in terms of its directions. So they've had an opportunity to deal with the legal point, and as I'll explain in a moment, in any event, non-retrogression doesn't change fundamentally the inquiry of this court. It inflects that inquiry and shifts the weighting when the reasonableness test is applied, but the test remains reasonableness. Secondly, Justice Rogers asked, well, they might, or suggested, that province and or the city might suggest that non-retrogression wouldn't apply on the facts because it might, the Tafelberg is public housing stock. We would submit that it's clear on the facts that a range of relevant role players identified this property as potentially suitable for social housing. Those included NASHO, the city, the province's own Department of Human Settlements, national government, and civil society. And all of that in the run-up to the launch of the proceedings. So it was very clear that the potential use of the property as social housing or affordable housing had been put on province's radar. So we submit that the issues are properly raised and may be taken into account by the court. There is no prejudice. We've developed the doctrine of non-retrogression in our submissions. We say it of the coin to progressive realization. That progressive realization requires us to move forwards, and non-retrogression is a check against backsliding. It is not an absolute rule. We don't suggest that anything that amounts to a retrogressive measure may never be undertaken by government. Rather, full justification is required. The doctrine now has a well-established lineage in our jurisprudence through Grootboom, Mazibuko, a line of later cases, and ultimately Commando. It has its roots in paragraph 9 of General Comment Mazibuko cited. And we've submitted that the appropriate test remains that of reasonableness. That was the approach adopted by this court in Commando and explained in some detail in the separate judgment of acts. But the majority also applies the reasonableness test, having found that a retrogressive measure is in play. The difference, and we refer to Professor Liebenberg's writing on this score, she also endorses the application of reasonableness in the context of retrogressive measures, with some slight adjustments to how the test is applied. We've made the submission that the relevant factors to be taken into account are those identified by the Committee on Economic, Social and Culture, identical terms by the African Commission on Human and People's Rights. They identify the same 6 factors in considering whether a retrogressive measure may be justified. Importantly, the Committee on Economic, Social and Cultural Rights has found specifically that the sale of public housing stock is a retrogressive measure in the context of the right to housing. Where the need is greater than the supply, an organ of state selling public housing stock constitutes a retrogressive measure. Again, that doesn't mean that it's automatically unlawful or absolutely barred, but it must be fully justified. We've pointed also to the concluding observations of the committee in relation to South Africa's own state report in 2018. There, the committee expressly about South Africa's provision of social housing and vision of adequate social housing in urban areas. So the Committee on Economic, Social and Cultural Rights has already flagged the issue of social housing in urban areas and South Africa's provision. The African Charter, I don't have an opportunity to further develop the submissions. They're in our written submissions, but they're really consistent with those of the Committee on Economic, Social and Cultural Rights. Explicit that where there is a retrogressive measure, it triggers a presumption of a violation. In our law, we would submit a presumption of unreasonableness that may still be discharged, having regard to the relevant factors that we've identified. So what does this mean for the issues in this case? We submit that both the intended sale of Tafelberg, and the overall policy approach of the city and the province constitute retrogressive measures, in very similar terms to what was identified by this court in Commando, a matter heard just over a year ago to the day. And we make the submission that what this court is confronted with is the general policy of the province, clearly, which has two elements: effectively housing in central Cape Town, and to be open to sales of valuable assets in that area. The crucial bite of our submissions is that in developing its policy position, and the same applies to the city, such disposals constitute retrogressive measures. This is a similar case to Blue Moonlight, where in that case the city of Johannesburg did not think it had an obligation to occupiers of privately owned properties. The failure to take into account retrogression, we submit, impugns both the intended sale of Tafelberg and the policy as a whole, and requires we submit a constitutional course correction vitally from this court, in the form either of a structural interdict or, at the very least, appropriate declaratory relief. Acting Deputy Chief Justice.
Thank you, Mr. Colleagues. No questions. No questions for the
as the court pleases. If I may begin with the declaratory and mandatory orders. When the Tafelberg application was instituted in 2017, there was no completed social housing project in what Dr. Nancy Odendaal defines as Central Cape Town. There were, however, 5 completed social housing projects in Cape Town. They provided 2,168 units and they were built at a cost of some 686 million rand. In addition, there was a social housing pipeline for 10,810 units in Cape Town at a cost of 1.2 billion rand, and in addition 14,008 units outside Cape Town at a cost of 1.57 billion rand. This is all to be found in volume 12, pages 1154 to 1165. When the answering affidavit was signed, the pipeline in Cape Town was 11,007 units, and another 3,844 units were in discussion. The social housing pipeline in Cape Town consisted of 42 projects, a few of which were withdrawn for various reasons. Of these 42, 9 are in Dr. Oudendaal's Central Cape Town. The NU applicants appear to have been unaware of all of this when the application was brought. After a comprehensive answering affidavit was filed by the province, NU nevertheless decided to continue seeking the declaratory and mandatory relief and the structural interdict that might flow from it. But there was a change of tack. One sees this in the replying affidavit, which is particularly in volume 28. It is now a complaint about priorities. So in paragraph 252.1 at page 282 Concourt, it said that the province regards addressing spatial apartheid settlement patterns as subordinate to the objective of delivering housing to as many households as possible. And in paragraph 245.2, just 3 pages earlier, it is said that it was the failure of the province to prioritize affordable housing in Central Cape Town that prompted the launching of the application. Both the province and the city have been entirely candid about this. For years, their priority was indeed to deliver housing to as many households as possible. That was also national government's priority. It was not an unreasonable priority. It is fully in accordance with what this court held in Grootboom, particularly the famous paragraph 44 of that judgment, where reference is made to those whose needs are the most urgent and to the needs of those most desperate. And the same principle was applied in Nazibuko, paragraph 67. Unequivocally, it is much more expensive to provide housing in the center of Cape Town than in more outlying areas of the city, which means government can provide more housing opportunities, accommodating more families away from the city center. But there's been a shift at all levels of government, or spheres of government, with greater emphasis being placed on spatial integration. This is described in detail in the answering affidavit. So paragraphs 120 and 153 of the answering affidavit, that's volume 11, describes all that the province has done and was doing in respect of housing, excluding social housing. And then social housing is dealt with under its own heading at paragraphs 154 to 208 in volume 11 going over to volume 12. Siri, the amicus curiae, appears to have overlooked this when it said in these written submissions in paragraph 76.2 the province doesn't implement its housing programs in Central Cape Town. It does. In paragraphs 132 to 133 of the answering affidavit, why other housing programs aren't implemented in Central Cape Town. Spatial integration, as the answering affidavit makes clear, is driven by social housing and by the catalytic projects, which are described in paragraph 135 and follow it. Fairly, with submission, Ms. Gooch, on behalf of the province, testified that the Western Cape government had made great strides in the delivery of housing under various housing programs. In the replying affidavit, NU says that those great strides are of peripheral relevance, as are the accolades that the province received from national government for its housing, but they aren't peripheral with respect. Government is performing its constitutional obligations by providing housing to the full extent for housing across a range of programs. So what one has now is a complaint by NU that the priorities should be different, with a different balance between the housing provided in various geographical areas. In particular, it is alleged that it is insufficient that 9 out of the 42 social housing projects should be within central Cape Town. That is what Mr. McCarthy says, and that is to be found also in the replying affidavit, paragraph 264.3, volume 28. What then is the correct number? If it should be 12, for instance, 2 to reduce to something like the higher costs of building in central Cape Town. Or there would have to be a reduction in housing for those most in needs because there's only this much budget available. That achieves the very balance described by this court in paragraph 73 of the Commando judgment of sufficient weight towards the most needy and vulnerable. So despite the shift in all spheres of government towards greater spatial integration, the priority remains the members of the most vulnerable groups. Save for very exceptional purposes, such as protecting the most vulnerable, our courts do not generally determine how spending by government is best balanced. Yet that is what NU is asking the court to do. In paragraph 2 of the amended notice of motion, which is in file 7 at page 670. The failure to comply with their obligations that this court is being asked to rule on is premised on a failure to get their priority in a way which is amenable to NU's views. If the department were merely paying lip service to its constitutional and statutory obligations, if it had been frivolous in its conduct, that would be, but I would submit that what is apparent from the answering affidavit of the province is that the department takes these obligations very seriously. It tries within the constraints of its annual budget to give effect to the full array of obligations as best it is able to. It is a very big province. It contains many cities and towns. Within Cape Town itself, as the papers indicate, there are a number of business districts. So the question of where to allocate housing within it and what kind of housing within a particular year should be built, or over a 5-year period, or over a 10-year period, these are questions that are inevitably complex and polycentric. They're spending decisions, they require particular expertise, legitimacy. In paragraph 71 of the Commando judgment, this court set out the defining features of the right of access to adequate housing. What the Western Cape government does in respect of housing is consistent with those features. In paragraph 71J and K, and again in paragraph 72 and 85 of that judgment, this court restated the principle of there being no requirement that housing be provided in a specific geographical location. The principle was qualified in that judgment, but the qualification was carefully circumscribed, as is clear from the order in paragraph 116 of the judgment. So in paragraph 116, there are a number of subparagraphs, Roman numerals. And paragraph 116.3 one moment, if you don't mind. Paragraph 160, the paragraph number is 4 of the order, and then 3 speaks of providing transitional housing in the inner city for evicted persons who have occupied land in the inner city unlawfully from the outset, but the policy doesn't do so for evicted persons who are former lawful occupiers, such as the applicant. So narrowly circumscribed provision. Roman numeral 4, again dealing with people in regard to foreseeable evictions resulting from phenomenon of gentrification. And 5, the failure to provide temporary emergency accommodation in the inner city to persons evicted from Woodstock when its residents have succeeded in resisting forced removals under the Successive Group Areas Act. None of those considerations would apply, at least not directly in the present matter. Nor is paragraph 116.2 applicable, because in this case, the province does not decline to provide social housing in central Cape Town on any basis. Indeed, on the contrary. The regeneration program of 2010 already included affordable housing in central Cape Town. The reference there is volume 12, pages 1180 to 1181, and the social housing pipeline represents a continuation of these objectives. So our submission is that the prerequisites for a structural interdict have not been satisfied because of obligation as alleged. The structural interdict that's now being sought from paragraph 5 of Annexure A to NU's practice note, which is to be read with paragraph 38 of its response to series submissions. Belatedly, NU appears to have recognized that a structural interdict in respect of affordable housing is unworkable without the participation of national government, a point that was made by the province and the city all along. National government holds the purse strings of social housing. Without specific funding from national government, no social housing project can even commence. And as Justice Majid pointed out, this national government also owns a lot of land in Cape Town. So now a report will presumably have to be filed at the High Court jointly, not by 2 but by 3 spheres of government. And the report, as envisaged, is to include telling the High Court what steps these spheres of government will take and when they will take them. So what NU is seeking to achieve is an acceleration of what the Constitution regards as a right to be realized progressively. It seeks to have the court impose a time frame where the Constitution does not. It asks not only for a timetable, but for an implementation of that timetable. This is at odds with Mazibuko, paragraphs 59 to 61, where this court said the following: the purpose of socio-economic rights is to ensure that the state takes reasonable measures progressively to achieve their realization. The court said also what the right requires will vary over time and context. And this court says ordinarily it is inappropriate for a court to determine precisely what achievement of a socio-economic right entails and what steps government should take to ensure its progressive realization. The draft order takes no account of the fact that the provision of housing is by its nature a work in progress. Facts change, priorities change, needs change, and budgets change. An example of that, in fact, would be the commando judgment and its consequences, because the city will now, of course, have to adapt its housing budget to take account of certain new requirements. The draft order with submission pays insufficient heed also to the context. The extent of the structural interdict that is sought is extremely wide-ranging and open-ended, perhaps much of that. 52 of our heads from this court's judgment in Mwelase, where this court said it is crises in governmental delivery and not any judicial wish to exercise power that has required the courts to explore the limits of separation of powers jurisprudence. Here, the department's budget and the way in which it allocates that budget will become subject to the High Court's supervision. The High Court will have to decide, with the assistance of Ms. Adonisi and the other applicants, whether the department Cape Town pass. The court will be unable to do so without considering also whether the department should spend less in George or Oudtshoorn or Worcester. This is haphazard decision-making. NU apparently has no difficulties with this. It says as much in effect, without using the term haphazard, in paragraph 107 of the replying affidavit. The reference is volume 27, page 2819, where it says this: the city's reliance, this is in response to the city, not the province, the city's reliance on central Cape Town not being the only inner city area within the Cape Metropole, and the spectre of the city potentially facing a number of repeated applications in respect of other areas such as Belleville, is misconceived. If such court applications are brought, they will have to be dealt with on their merit. That, with respect, is no way to pursue housing. If I may turn then to the regulations under the Western Cape Land Administration Act. It is now only NU that challenges Regulation 4.6 and the proviso to Regulation 4.1. The National Minister has abandoned the challenge. There are two grounds for the challenge. The first is based on a statutory interpretation, namely that Section 3.2 of the Western Cape Land Administration Act requires the notice and comment procedure to take place before a contract is provisionally concluded. By provisionally concluded, I mean with a term saying the province may, or the cabinet may unilaterally resile from it. Before a contract is provisionally concluded, and indeed before the decision to dispose is taken. The second ground is an argument from psychology, namely that once a provisional contract has been concluded, the decision maker will be disinclined to, therefore the process becomes procedurally unfair. As to the first ground, there's nothing in the language of Section 3.2 to suggest that the notice and comment should precede a decision to dispose. Indeed, I would submit that proposed disposal, that very phrase, signals the contrary. It's also illogical to call for comment before any decision about possible disposal is taken. There's also nothing in the language to suggest that a provisional contract can't be concluded before notice and comment takes place. The definition of dispose in Section 1 includes registration of a real right, a right in land. This would include presumably something like a servitude, but also include a servitude created by contract. Yet disposal there clearly only takes place on registration expressly. It's registration of the right in land that's the question. And one can therefore reasonably interpret the word sale also as meaning registration. That's the relevant process for the purposes of this. We've made submissions regarding why it's sensible to resile. Also, it's a more sensible process of obtaining comments when the purchaser is known, the purpose of the acquisition is known, the price is known. I do not understand any of you to be arguing for the imposition of more than one notice and comment procedure, one in the abstract and one more concrete. That would in any event be to impose an unwarranted cost on provincial governments, on the Western Cape government. Second ground, the argument from psychology, this is to contend that the decision maker won't have proper regard to the comments that are received in the course of this process. Our submission is that there's no basis for assuming that this is so again in the abstract. Precisely because this is the process, there's every reason to think that the decision maker will consider seriously all input, all comments. Again, practical considerations favor this way of doing things. If, of course, the decision maker can, in any particular instance, be shown to have closed her or his mind, and not to have challenge may be brought, but that would be on an ad hoc basis. Turning next to Guillaume, there is a chronological difficulty with the interpretation of Guillaume that is advanced by the NU applicants and by the National Minister. Guillaume was only enacted in November 2007. It had a commencement date for national government departments of 30 April 2009 and for provincial departments of 1 April 2010. Had long since adopted their own disposal acts. The first one was enacted in 1998, the last one in 2003. And had been disposing of property, obviously, in terms of those acts. So the argument would have it that those disposals should have come to an end. There should have been no further disposals from the commencement date of Guillaume until the process of compiling UAMPs and CAMPs was completed, which we know on the facts is a very long process. Absolutely enormous, including for housing. No transfer of housing from the state to social housing institutions could take place. No individual land titles to breaking new ground or for breaking new ground housing could be transferred. It is quite a submission with respect for the National Minister of Human Settlements to be advancing. Section 13.3, which deals with the disposal of surplus assets, contradicts this interpretation. It references provincial land administration, written 4 of our heads of argument to the concession made on behalf of the national, that it isn't necessary for a provincial government to consult the national minister in regard to every disposal. Our learned friend, Mr. Jamie, says it's not a concession, but whatever it is, that every disposal. Our learned friend, Mr. Jamie, says it's not a concession, but whatever it is, that is the position adopted. What is unclear is when, according to the national minister, it's necessary to do so. The argument seems to focus on the need to have done so in respect of the Tafelberg property. This court will decide the question of mootness, but our submission is that that's not a live issue. That Tafelberg property, the contract has been cancelled. The National Minister refers to 3 provisions in Heads of Argument, paragraph 154, section 41, 1H4 of the Constitution, and section 5A and B of ICFRA. None, however, in our submission is capable of founding any general duty to consult, and in any event, as we now know, no such duty is being asserted. What is sought is one of the High Court order, serve. Our submission is that the autonomy of each sphere of government, which the Constitution provides for, the relative autonomy, makes this a strained approach to disposal of property. To have to go and consult with the national minister when provincial land that can potentially be used for housing, as is common cause, I think in this case most land can be used, is to impose something that in our submission simply can't be followed. We would submit in regard to the minister's application that there's no good reason for this court to grant the application for leave to appeal. As the court pleases. In our submission, no, it was not necessary. Yes.
What does the Act say? With some kind of requirement on the part of the consult with that side,
Our submission is there's no such requirement in Guiama. In other words, there's no requirement there that there be consultation with the national minister. I'm not sure what provision Justin Klankler, you have in mind, but I'm not aware of anything that says that. And we've taken this position that these are intra-sphere of government administrative provisions. In other words, your custodian will typically be the Department of Public Works. The users will be the individual departments, including that department, but also all the others. And there will be a process within the particular sphere of government at national level, provincial level, all the provinces are implicated by this act. And a process will be followed as indicated by this, which includes the preparation of UAMPs and CAMPs for what we say are management purposes. And I've referred the court to the disposal provisions which have been raised. Of the Yes. But again, the court will have to interpret that, we would submit, in a way which is sensible. So one has here a framework provision in talking about the principles of cooperative government and intergovernmental relations. They must cooperate with one in good faith, and then it specifies various things there, and that includes informing one another of and consulting one another on matters of common interest, coordinating their action and relation with one another, and so on. But to interpret that with respect as a requirement that every province, before it disposes of any land belonging to it which could potentially be used for housing, must first consult with the National Minister of Human Settlements, would in our submission be an undue burden. In other words, that's the kind of thing that one may try and find in some form of legislation. The difficulty, of course, would be that provinces have their own constitutionally entrenched areas of competence, and that would include, we would submit, the power to dispose of land belonging to them, including for revenue-raising reasons, as was a reason for the disposal of the Tafelberg property. And it would be, we would submit a very severe imposition on provinces to require this. We did also make the point, and I think you raised it also, Justice McClantler, earlier, we raised the point in our heads of argument that why would it only be housing then? What about, because property can also be used for police stations and schools and all kinds of other potential. Where does the obligation to consult then end? And one's looking then at long processes, much delay. I would submit that that would be an imposition which is not anticipated by Section 41 of the Constitution.
In this case, though, it is not a case that the government has within the province, an interest in the province.
It did. And then I would submit, typically, at an intra-government level, there were negotiations. And the Department of Human Settlements internally was offered certain things. They said, fine, we withdraw our indication of interest, and it could then be used for other purposes. Learned friends said they were bullied. I think that's an unfair description of it. These were negotiations, and that's where it ended up. And again, so no dispute that Tafelberg is a property that potentially, it did have a small area of housing on it. The Wynyard Mansions part of it was small, but there was some housing on it, in fact. So it's not like the whole property no part of the property could be used for housing. But you will recall that a very, very detailed study was done by including the financial model that went out for comment. And the upshot of all of that was that it's not suitable for social housing. And one of the factors was it's not in a restructuring zone. So there'll be no funding for it in any event. Yes.
That they've been in the pipeline cases, and you seem to be, because they're there, at least not exactly, how is that possible for ages? You only mentioned 5 committed
At that stage.
are not
Correct.
central picture
Correct.
in other areas. Because it's going to be this pipeline process, so why not
Yes.
take that into account when post-apartheid?
Yes. The court must consider at the time when the application was launched whether the province was failing in a constitutional obligation. Our submission is that it's relevant that the province pipeline had already done some social housing, bearing in mind the province says openly there's a late shift. It does say it in all spheres of government towards a more emphasis on spatial integration rather than just providing as much housing as possible. The shift takes place, 5 are done, and there is this lengthy pipeline set out in very great detail in the answering affidavit for more to come on stream. At that stage there was nothing in central Cape Town, but the pipeline provided for 9 out of the 42. Now the court can say, well, it's too late, should have been done earlier, but with respect, it wasn't done earlier, partly out of a policy issue, as I say, the Grootboom approach to housing. Let's look after those most in need first. There's definitely a change in emphasis, but one does. Yes. So it only not be meaningful participation if the court accepts the argument that the decision maker's mind is now made up. If the court accepts that argument, then I have no answer. Then of course. But the submission we make is there's no indication that the decision maker, it closes the decision maker's mind. So all that the province is trying to do is have as meaningful as possible a public participation process, which it believes, rightly or wrongly, but it believes is best achieved by having as much information available on which to comment. Firstly, so one has, in other words, for province to go out and give notice and ask for comment, saying, we've got a piece of land, could we have your comments on it? That seems, with respect, to be relatively insufficient or ineffectual as a way of going about things. Instead, they go out to tender, they get tenders, look at the best tender, they sign the contract, but with this express right to resile with no consequences. They've now locked in the purchaser. It's a very important consideration. Nowhere to go. The purchaser locked in. The purchaser can't resign without a damages claim or specific performance application against it or action. So you then ask for comment. That comment, I would ask the court to accept. Those comments, I would ask the court to accept that the decision maker approaches this in good faith and looks at the comments seriously and has not closed his or her mind to the outcome of this.
That's what interesting. In this particular property, the offer was
135 million, yes.
155 million. So, the contract is signed, the agreement is indicated. You still want someone to come and say they will take it when it's 135 million?
Yes, because you will recall that the process that was then followed was very detailed, and we have the minute of the cabinet meeting where this was process. It was not simply some kind of tick box exercise. It was detailed. The financial model was put out for financial model was created and put out for comment as well. This was a long and very careful process. Now, one can say, oh, all of that was just smoke and mirrors. But with respect, that's to say there's no good faith on the part of government. And there's no basis for that with respect. So if one assumes good faith here, this was a genuine process of engagement. And there are, one sees ultimately, sound reason for property for social housing. The province also says, look, we were looking to raise funds. We were in a situation that we needed funding, and they had a specific project in mind, which was in the education department. But certainly, if this is done in good faith, then it seems with respect to be a sensible process to follow.
Along those lines, can it be said that have complied with the obligations to redress spatial apartheid when they don't provide affordable housing in the city centre?
Yes.
Given the legacy of spatial apartheid in the city centre, and we refer to the question of cost,
Yes,
it's always going to be more expensive.
exactly.
But by only providing social housing on the peripheries of the city, spatial apartheid becomes inadvertently, maybe expressly mentioned.
Well, that's a question of what one regards as spatial apartheid. If you're talking about the apartheid legacy of this country, that's a race legacy. It's not in other words, it has economic consequences, tremendous adverse economic consequences. But insofar as we're addressing the race aspect of it, the racial aspect of it, then social housing is a sensible way of changing the demographics of an area, including central Cape Town. If one is looking for something different, if one is saying there should now be more of an economic integration as well then it would be different. Then one would go to then one would have to say there must also be housing for the very poor, in other words, the Breaking New Ground candidates, or the REP housing, it was called previously. But that, with respect, it is not, as I understand it, the thrust of the case. In other words, social housing is the program that is applied for these purposes. The people who can't afford, who don't fall within those bands, those income bands that are determined by national government, they don't yes, you're quite correct, they don't qualify for social housing, and there's no other housing program on the papers envisaged in central Cape Town.
So those people will always be housed on the property.
Will always be housed.
Be housed outside
The very poor, yes. Yes. Well, I can't say always, but under the current programs, yes. I can't at all. I don't know what changes there may be, but I can't stand here and suggest to the court there's any other program. If you give me 1 moment. Yeah. So there the emphasis is on numbers of houses in line with the Groot approach to it. If this court says that's not good enough, and all the provincial government should also ensure that there's housing, there's breaking new ground housing in the centres of cities, then that's something that the court would decide. That would be a determination made by this court. But this case has very much, as I understand it, the thrust of the case has been not that. It has been a case that's been focusing on social housing as the way of redress, only partly. Of course, it will take a long time. There will be there will be much further funding that will be required. Many further housing opportunities have to be provided over time. But that is certainly the focus currently of the way in which to address spatial apartheid, yes.
When the state has land in the city, in our particular Cape Town,
Yes.
must it use that land to progressively realize socioeconomic rights?
Yes.
And would the decision not to use that land be unreasonable in terms of its obligations in Section 26 of the Constitution?
No, not per se. Now, it was not simply, because one cannot, for example, say that in regard to a particular parcel of land, a particular piece of land, which can be used for social housing, it must be used for, or for housing, it must be used for housing. There are various, in other words, in-use complaint precisely seems to be a lack of a policy. In our respect, we don't agree with that. We say that there are programs in place, there are a range of programs, but there can be no jumping, we would submit, from the fact that land can be used for social housing to a conclusion, therefore it must be used for social housing or for any form of housing.
What would the consequence be of this court finding, as the emphasis argued, that the sale of public housing constitutes a non-retrogression measure? Would this amount to a failure of the province to fulfill its obligation to progressively realize the rights in Section 26?
No, with respect, and again, you'll see the definition that's used by Siri is that housing stock is something that has been used for housing or that can be used for housing. Now, let us say the province decides there's a large piece of land and they decide that it's appropriate for a school. And it also has obligations in regard to education. Or it says this will be appropriate for a hospital. It can be used for housing, but we'll use it for a hospital or for a school. One cannot per se say that therefore it follows that it's breached its obligations.
I'm sorry to interrupt you, but here, where specifically it sells off the land.
Yes. So you know,
There's a difference, I think, in the case where it uses that same land,
yes.
perhaps for a hospital. The difference in that situation and where it sells off the land.
Yes. But with respect, I don't believe this court is going to find that the provincial governments, or national government for that matter, are precluded from selling land where they desperately need revenue, for example, for the fulfillment of their constitutional obligations across the board, only because that land can be used for housing.
You see, one must also have regard to Section 2(1)(e) subsection 4 of both the Housing Act and the Social Housing Act.
Yeah.
Principles for the implementation. Must also keep in mind Section 7(2) of the Constitution.
Yes.
Places on the state a positive obligation to respect, protect,
I would submit by not peering closely at every specific transaction. In other words, to interpret these provisions as imposing on government a duty not to sell any land that can be used for housing, even though the funds are desperately needed, as was the case here. To impose, and where the land was not suitable.
I'm sorry to
Yeah.
interrupt you, but
Yeah.
I think we can move from the premise
Yes,
the funds will always be needed.
yes, yes. One can move from that premise.
Funds will always be needed by government.
Yes,
So we justify the need for funds, not as opposed to them not fulfilling other obligations that are in the Bill of Rights.
you know, with respect, there are many obligations in the Bill of Rights, and the province must address, and we've dealt with this at length in our heads, address all of them. And it does. It sets out to do so. But I cannot with respect agree that these provisions in the Housing Act and the Social Housing Act mean or should be interpreted as meaning that therefore province is precluded from selling land that can be used for housing.
The case at the end of the day for this moment is whether the conduct was reasonable. Was reasonable come to
Yes.
the equation?
Yes. Is the court referring to the Tafelberg decision specifically? Yes. But that
Because we have to make that
yes. Although the Tafelberg sale, of course, is no longer extant. That's fallen away. Yes. Thank you.
Few concerns about, if you like, conceptually, the notion of spatial justice. This case has a geographic focus. Clearly, city centre and with policy calls with an obligation to provide access to land which may be used for social housing. But it is, if you like, spatially circumscribed. The innocent debate is whether it extends to Woodstock, beyond Woodstock, to observatory, and so on. That's what I'm finding really the concern is, well, what is the metric that one applies to measure whether social justice is achieved? Is it, for example, solely confined to availability of land, making land available for a particular use? Or does it indicate questions of amenity, access to amenity? So distance, employment of clinics, hospitals, creches, that seems to be an important question, because if hypothetically one had land made available, not in the city, but a little bit more distant in observatory program, extensive social housing program made available together with transportation and a range of other amenities. Would that set of facts be relevant to tell you whether spatial justice is achieved and the rest of the policy based
My submission is it would very much be part of it. And it is also part of the province's case, and I believe the city as well, that the province certainly says they're well aware the city of Cape Town, the CBD, it's a confined area and they're business districts. And the idea is to develop those business districts. Everybody can't work in the CBD or can't accommodate there. The city's becoming very large. I think it's now 5 million people. So I think that the access to amenities is dealt with in the commando judgment. It is part of it. We accept that completely. But there are various ways of achieving that, short of having housing in central Cape Town. Of course, having housing in central Cape Town is a very good thing, and the social housing program recognizes that, but there are other ways also of seeking to achieve similar results. This is not the only way of doing it.
And so, what's the non-forest agreements that needs to be applied in the assessment of the reasonableness of the policy?
Yes.
And concomitantly, whether there has been a failure in the equitable obligation, either redress historical patterns, settlement, or failure to comply with achieve status.
Yes. May I make those two questions, as it were? It's common cause that redress has not nearly been achieved. That would be utterly unrealistic, of course, for anyone even to suggest that. So the question is whether the obligation to progressively realize these rights is being complied with, and our submission is it is. Just on the question of how widely does one look at this, I did mention this before, but if I may just read to you what the answering affidavit says in volume 11 at page 1119 about the use of the catalytic projects, described there as a recent initiative of the National Department of Human Settlements dating to 2012. They're intended to be spatially targeted interventions, the main objective of which is the digital patterns. These projects, once completed, will yield over 100,000 housing opportunities both within the Cape Metropole and in non-metropolitan areas. The catalytic projects will benefit, among others, the airport precinct area, which includes Guguletu, Nyanga, Delft, Philippi, and the city. And then there's a whole range of these. So what these are projects exactly along the lines, Justice Wilson, that you have been raising, which is other ways of giving people access to amenities than putting everyone, because of course that can't be done, particular location. As the court pleases. No, on their definition.
I know, but you have to show that it's complete horseshit. So it's not public housing stock. We've all just accepted that their version of this being public housing stock is correct. It's not public housing stock. So 3/4 of the site is not even possible for housing.
Yeah, well, I didn't make that point, but you think I should...
Yeah, I think you must make it here. And they've accepted his version completely.
Yeah.
Yes,
that may be difficult to quantify in money terms, but in the context of the public also say. And so, would I understand paragraph 24 of the Real Statute that says in certain circumstances it might be inequitable that spatial justice is a component of adequate housing and a test of reasonableness.
Yes.
And if we should conclude that your clients may not have seen that movie,
Yeah.
in the sense you don't have the right to a house or really want it,
Yeah.
that the applicants may have delayed benefit in the applicant's case, at the very least, the respondent should be able to say how the commitment to spatial justice is actually maintained in their policies and programs.
Yes, I'm sorry, I just missed that last bit. Sorry, Lisa.
Would the applicants not have a case in saying, well, we don't know to what extent, and we accept that there's a commitment to provide social housing,
Yes.
but we don't see that commitment as incorporating the element of spatial justice, and therefore those policies should be more explicit,
Yes.
expounding that.
If I may say, I don't understand that to be the applicant's contention. In other words, they don't seem to suggest, as I read their papers, and I maybe have misread or overlooked something, Justice Colopin, but they don't seem to suggest that social housing, if there were to be social housing in Central Cape, that wouldn't be some form of.
But the argument is that there's been a failure to
Certainly, and that's it's common cause that when the application was instituted, it hadn't happened in regard to Central Cape. Yes.
because it should start on as a key response. In a sense that you have the proposals that have gone up, the responses to an evaluation. Whereas what we have here is a decision taken to sell.
Yes.
Implicit in that decision is really a communication to the world at large. And that we think this is a good decision from a cost benefit analysis. We think this decision is one. We don't think we believe that this decision gives effect to our legal and our constitutional obligations. And this is the best decision under the
I don't know, what happened in this case was that after the High Court judgment, as I understand it, the sale was cancelled. The family initiated issues and mootness. Now we are on this process. This is not even remotely of my thinking. One of the litigants before the court found as well, but notwithstanding what this court may say, we already got plans for the court in or must we just complete
Respect for submission is because of the fact that became moot.
part of the land that he was considering innocent because we know it's very scarce. And we must consider when we look at the list in this case.
No, with respect, Justice Majority of land. It may, of course, its background. Certainly, it's part of the facts before.
Part of the bigger picture, you're looking at all the land in the innocent this land that may be available.
Yes.
When it comes to addressing social housing issues.
Yes.
We're going to make decisions basically here that's in principle, not going to concern the same.
Exactly. Exactly.
What I'm saying is this is part of the bigger picture, isn't it?
Yes. Yes, but it's only part. In other words, there's no relief being sought at currently. The fact that that was the genesis of this case, with respect, doesn't affect that. Currently, yes.
Let's say we got an agreement with, for example, national government that we could use part of land and we're not using a piece of land.
Yes.
Therefore, space has come abundant or something like that.
Yes.
I'm just postulating to you a difficulty that I know these kind of decisions are made
Yes.
Yeah, you say it will take months before the judgment comes.
No, graphs of this. Now that national government saying this must be considered by a custodian.
Now, is your case that, and I'm focusing on what Mr. Jamie argued. He says there's been a position here where the recently identifies the land for affordable housing, and the minister takes an interest in it, national minister. But then the Department of Public Works in the Western Cape persuades the Department of Human Settlements to retreat
Yes.
and to withdraw their expression of interest.
Yes.
Doesn't that undermine 5.1F?
No.
Even if it's only for your benefit, I give the benefit of the doubt, and I say you are being client, even if it's only indirectly and not deliberate.
Yes. But it's only it must be considered. But there were many factors. This is one of those, again, complex, polycentrically considered. And again, the process in regard to disposal of Tafelberg was a remarkably detailed process and long-running process. One does have an interesting parcel of land where a lot of it is heritage. It was a school primarily. That school moved out to the northern suburbs. It was therefore not used. There was a small section that was used, Wynyard Mansion, limited accommodation. Those people in due course, those occupants in due course all left. And the view that was taken ultimately, for a range of reasons, but one of them was that it's not in a restructuring zone, from which therefore the funding wouldn't have been there. This is not suitable for social housing. Now that's a considered, and on that basis, not to resile from the contract that had been concluded with the school. It was that it was a school, and now it would be a school again. Of course, another factor was that it was a school, and now it would be a school again. These are all relevant factors. So it's a conspectus of issues that are taken into account and were taken into account.
Was the interest expressed by the minister soon taken into account during the succession?
Yes, I'm not sure that like interest expressed so much. In other words, in acquiring it, it was a matter of, we need to talk about it rather than. And the Premier said, "I'm fine. I'm open to talking to you." She said, "I'm not obliged to talk to you." She didn't accept that it triggers an obligation to speak, but she was willing to speak to Minister Sisulu. If Section 41.1 applies, my submission was that Section 41.1 does not oblige a provincial government when wishing to dispose of land belonging to it, having taken consideration of all the relevant factors, is obliged to consult with national. May I just add something? The court will be aware that the part of the disposal under the Western Cape Land Administration Act requires notifying national government. Not specifically the Department of Human Settlements, but national government is notified. Two departments of national government. Great respect, yes, it was our argument. So on the Section 25.5 point, you have a note somewhere, but there are only two references to it in the founding papers, and both are, I would respectfully say, insignificant. There's one simply where the constitutional, I think that was the one that was referred to earlier. Thank you. Yes. So paragraph 104 at page 56 of volume 1. And then the second reference, and that's simply stating that there is this right, and then the other one is page 71, paragraph 143. And the court will see there that it's referred to at the end of paragraph 143 of the obligations, but then it goes straight into section 26 obligations after that. So the rest of paragraph 143 is that. So section 25.5, therefore, I would submit was fairly described by us as not playing any kind of central role in the case that was initially brought.
Policy.
Yes. No, I don't believe that it produced any particular document in that regard. It produced a range of evidence. But can I just say, in the founding affidavit, and this is page 31 of volume 1, paragraph 57, what he said, it's apparent from the above summary of the regeneration program that the applicants are concerned. Oh, sorry, my apologies, that's the wrong one. That's the one where they say, was a different one where, oh, sorry, it is that one. The applicants are concerned primarily with the manner in which the province and the city have implemented their policies rather than the programs themselves. And we had rather understood that the case we were meeting was an implementation case rather than a policy. In other words, produce the policies case. There seemed to be a contentment with the policies. Yes. 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 I agree. In fact, if one looks at in volume 1, paragraph 49, what he said by the applicants is they refer to the regeneration program formulated in 2010 has since been updated. This is the policy in terms of which the province seeks to sell the Tafelberg property. The regeneration program should be viewed against the broader context of the Provincial Spatial Development Framework. So that was there as well. And then the city's Municipal Spatial Development Framework. If you're considering the position at the time the application was instituted, it would appear it was still in existence at the time.
How it came to an end, and the applicants said that although the fact that it came to an end seems to be stated, just in the answer. That from said until the full body statements that as a reasonable measure of giving effect to the relevant section 25 or 26 rights, there should be in existence a written document, several documents necessary, which inter alia contain the province's plan for addressing spatial injustice and the provision of social rights.
Yes.
If we find that it in fact did not exist, then at least to that extent there would be there might be ad hoc things being done and planned. And if those have been part of a coherent plan, the absence of a plan would surely be problematic. We are years on, and on one hand, the council has the time yet. On the other hand, I'm sure the school would want to make any order if it finds it coming to somebody. We want to make an order that is relevant rather than simply academically stating what the position might have been in 2017. If there is a reluctance by the court, say there will be, if there is a reluctance by the court, have any ongoing role in adjudicating the adequacy of the plan, would there be any difficulty in order that required the plots furnished to the applicants, generally publicly available, the documents containing the plan as they exist now? Not on the footing that it must be submitted to the High Court, on the basis that the applicants will then be entitled to consider that plan if they can view, they can then launch a review to attack whatever the current plan is.
I think I must fairly just turn around and see whether I can take an instruction on this before making, but it does seem to me with respect a fair proposal, speaking for myself, but if I may just, yeah. Oh.
And also it might be helpful to us to know whether such a document really exists, even if it came into existence after May 2017, whether it is something that problems with that line.
And whether it's one of the many documents, what it is, yes. Thank you, please.
Deputy Chief Justice. The city does not take issue with the fact that it must take cases of spatial apartheid. We endorse the views expressed by Justice Colopin earlier when the proposition was put to my colleague about the need to address apartheid, the removal of people from economic opportunities historically, and the deprivation of access to amenities. We make that very clear in the affidavit of the city manager. Thousands of people who commute daily in Cape Town to and from different economic nodes, not only the CBD. And that the backlog in housing grows annually. The city is not able on its own to keep up with demand. It does not own sufficient land for Cape Town or be it around the city. And that has been the position which has prevailed for a considerable number of years. And I'm going to come to the issue of land identification in a moment, but needless to say, this occurs in the context of dwindling budgets and a continuing influx of people into the Western Cape. So what is before this court are affidavits from the city in what the city has done, what the policies the city has implemented, and the challenges which the city has faced and continue to face in its planning to progressively realize access to housing. And access to housing has many facets, from emergency to social to gap housing, and many components of it, some of which emanate from policies in the past, some of which emanate as a consequence of court judgments. Now, in the High Court, the judgment itself confirmed that what was before the court in respect of the manner in which the Constitution and the statutory obligations had been implemented. It was not a challenge to the constitutionality of the policies, but the manner in which those policies had been implemented. There was no attack on any legislative provision, and there was failed to comply with any legislative provision. I note that it's now been belatedly raised before this court for the first time. And So at the outset, as a general proposition, the court should note that the CBD and the surrounding areas is not the only areas that are close to economic opportunities. There in the CBD, there is mostly state land which could readily be made available to the city for purposes of social housing. The social housing model means that the city receives a specific restructuring grant if it's in a restructuring zone, which would assist in providing affordable social housing. But the demand is great, and we're never going to meet the demand of the number of beneficiaries that would want such. Now, it's against that background that we make the submission that this case is distinguishable from the Commando case in one significant respect. This court had found that in the Commando case, the city had not acted reasonably because it had excluded emergency housing options entirely from the inner city. This has not been the position of the city in respect of social housing. And I noted Justice Majid's comments in respect of it would have been helpful for us to put submissions in respect of the Commando case, but we didn't. And what does come out is that the affidavits in the court in the Commando case were later affidavits. So it built on and it made reference to the affordable housing policies which are touched on in the affidavits in the Tafelberg matter and elaborated in the affidavits before this court in the Commando case. So it's in that context that the court in that case found that the city had the requisite social housing policies in the city, but it didn't make an accommodation for emergency housing. The position in the Tebolisha case remains as the Constitution does not guarantee a right to housing at government expense at the locality of his or her choice, and the locality is determined to accept by a number of factors, which we say must involve availability of land, and that the government must have regard to the relationship between the location of residence, access to employment, schooling, and other social needs that is required. But the key driver in human settlements development must be available land, because without adequate and suitable parcels of land, the city can't develop affordable or deliver affordable housing, be it in the CBD or elsewhere. And when this land was identified, and we know that the then Mayor De Lille in 2014 wrote to the national government, we see that at Annexure LM1, Volume 4.2, there was no response received. We also note that in answer to a question from the bench as to where does the right find itself, the response was that it finds itself in the Housing Act in order to seek to have a right of social housing in a particular geographic area. And that in the heads of argument, the applicants for the first time raised that the city had failed to comply with subsections 9.1c of the Housing Act and 5c1 of the Social Housing Act, which relates to the identification and designated of land for housing and social housing, specifically limited to the area in or near the CBD. But on a perusal of the founding papers, these provisions were not even relied on or expressly stated when the city answered the applicant's case. So we faced before this court with a new case that we've come to meet that hasn't previously been argued. And we submit that firstly that's impermissible, but in any event, if you have regard to Section 9 of the Housing Act, it requires that the city, as a part of its process of integrated development planning, must take reasonable and necessary steps within the framework of national and provincial housing legislation and policy to identify and designate land for housing development. It does not say where the city has to do so, or which of its housing obligations should take preference when it does so. Against that background, that we know the applicant's case, the impetus was the Tafelberg land. That land was not owned by the city. The city was not part of the decision to sell the Tafelberg site at market-related rates, nor was it part of the decision in relation to resolve from the contract with the third respondent. So we take issue when the amici makes a broad submission to the school to a joint approach by the city and the province to sell off state land. There isn't any evidence before this court that the city was party to the sale of state land. That brings us to the question of when the applicants summed up their case, they made it clear that the use of state-owned land lies at the heart of this application for purposes of progressively recognizing the right. And we submit that for the court to grant the relief that the applicants seek against the city in respect of non-compliance with sections 25 and 26(1) and 2, then the court must find that the city is compelled to develop social housing in central Cape Town, irrespective of cost implications, for purposes of redressing spatial apartheid. A person requiring social housing can demand the location of social housing to be provided at such location or any other location for that matter. And on the basis of the argument made that unless the city provides social housing to disadvantaged persons in every economic node, it in effect contravenes section 25 and 26 of the Constitution to the extent that it can be argued that to do so would be a progressive realization of access to housing. Now, the applicant's case on the founding papers, what was it? It's set out in paragraph 144, page 72 of the founding affidavit, and it relied solely on the evidence of Professor Malcolm McCarthy. In fact, my learned friend started his affidavit by relying on the affidavit of Susan Parnell. And his one criticism is that as an indirect consequence of an urban generation project that occurred in the late 1990s, which is an investment in buildings and developments with a knock-on consequence that it made the city unaffordable for lower income households. That's the high watermark of his criticism, save for his last paragraph. And his last paragraph, he says, he refers to the central Cape Town for the first time, which he doesn't do in his affidavit, and he lumps the province and the city into one and complains about the Tafelberg land without distinguishing as to which entity was actually responsible for the sale of the land. He does point out that the city has made certain sites available, the areas of Woodstock Salt River, and he sets that out. But nowhere does he make the point that provides the applicant does in its main affidavit. With reference to Professor Parnell, and she refers to SPLUMA, which comes into effect in 2013, as being a significant step in advancing spatial development framework. And she points out that it calls for the transformation of the apartheid city by, amongst other things, where appropriate, using state-owned infill sites to help reconfigure the distribution of land use and people. As far as the city is concerned, she points out that the city routinely cites availability of land as one of the primary barriers to the expansion of affordable housing. If the delivery rate were to be drastically increased to 20,000 units per year, it would run out of land suited for housing development within 5 years. One of the main reasons cited by the city to explain land shortages is the large number of well-located sites regarded as well suited for development, but not transferred to the city by other levels of government, including the province. What neither Ms. Parnell does, nor Mr. McCarthy, is make out a case that the implementation of the city's policies are unreasonable, being the case which they find a breach of constitutional rights. So that takes me to, well, what are the policies? Can one say that the absence of housing opportunities in any designated geographic area in a policy does not in itself amount to a constitutional infringement. Can one say that anybody, any person has a constitutional right of access to land and housing in a particular area? And we submit that to find a breach of a right, you've got to read 26.1 and 26.2 together, or you can find a breach. And the internal limitations of 26.2 shows that if there's a progressive realization of rights within available resources, and the city can show that, then there is no breach of a right. I make common cause with the arguments that Mr. Fagan put to the court in respect to it. And so in the context of this case, there is in order to come home on a failure to implement these two misconstructions. Now, one, that we have developed only on the periphery at the expense of the inner city, and I want to put that into context in a moment. And two, is why we disputed this issue of Central Cape Town, and I want to just touch on that briefly. So on the first misconstruction, when 1994 comes, the city is not sitting with zero. There's a huge inherited backlog of housing. Emergency housing is required. Informal settlements and upgrades is required. There's no order of precedent. There's a need for spatial integration. The national government and the provincial government directs the policy at the time. The very same national government that the applicants say didn't do anything wrong, which is why no relief was sought against them, is the architect of the process which said build as much houses as you possibly can, emergency housing, but also integrated human settlements. The implicit too was the need to restructure cities spatially in a post-apartheid period, resulting in projects like the Breaking New Ground resolution, also orchestrated and through the national government. Apart from that, as we see things, as other provinces run into difficulties, you see an influx on population growth, you see land evasions in occupations, and you see court judgments which hand down and say, well, the city now has an obligation to find alternative housing, both for private land and unlawful occupiers of public land in circumstances where development is required on that land. And in the city's 2012 municipal spatial, by amongst other things where appropriate, using state-owned infill sites to help reconfigure the distribution of land use and people. This was for all areas. The complaint in this court is we didn't specifically do it for the CBD. Nkrumah came into operation in 2015, and it saw the advance of social housing through the policies under the Social Housing Act and spheres of government, including the national government, which owns vast tracts of lands close to the CBD, should have shouldered responsibility for advancing the rights of the poor under Section 25 and 26. So, the city answers at page 230, 2330, volume 222, the projects that it did from 2010 to 2017. And then came in the difficulty which the city had, because if Dr. Odendaal in the construction of Central Cape Town didn't arbitrarily determine where it was to be cut, then if you look at the map, which you'll see, it's a document like this at page 680 of the record, you would see very clearly that one of the boundaries, and it shows up much clearer, David, one of the boundaries was the Kubit interchange. And immediately next to the Kubit interchange are the two places that the city did develop social housing, be it in the making, and that included for the provision of affordable and social housing within the surrounding area to the CBD. And this, I submit, preceded 17. And one sees this 1178 and 1778 and 1779 in volume 18. The start of the explanation on the affordable housing prospectus, 1778 and 1779, which gives you the date on which the organizational development and transformation plan was adopted for purposes of effectively prescribing how new developments across the city would be implemented to redress apartheid spatial inequality. And so when the prospectus gets published in 2017, it follows on the planning of which commenced in January 2016. Refutes the proposition by SERI in paragraph 6.31 when they submit that the city had a general policy not to provide affordable housing in central Cape Town. And it also refutes the submission that the city's position is that it is legitimate and defensible to sell immovable property in central Cape Town, when none of that is apparent from the record, not the case put before this court. Maybe a good paragraph to refer the court to is what this court said at paragraph 69 of the commando judgment. Due to the need to address the inequalities of apartheid and resultant spatial disparities, the social housing program aims to achieve the development of high-density, subsidized rental housing in designated restructuring zones. These are areas identified for the provision of access to economic opportunities and urban amenities on a more permanent basis to people who are slightly better off and have access to some income. Overarching goal is security of tenure. Justice Theron put the proposition to Mr. Fagan earlier as to who exactly does this target. And the answer one sees at 1789 of the record, with the 789 of the record of Annex to JG 40. It's part of the affordable housing, and it gives you an overview of the housing apologies. And it sets out affordable housing in the context of the prospectus, with reference to the provision of social inclusionary housing within certain bands of income to do that. What it also does in this document on page 1798 is it shows the sites that was to be released. And this becomes relevant because by the then maker who had oversight of the Transport Development Authority as saying something along the lines that, let me not misquote it. The question put to him is, why has it taken on well located affordable housing? Part of the answer is probably in the explanation I provided to the court, but this is the answer that Mr. Heron gives. That's hard to answer. And then he says, the parcels of land that we've just released are city-owned in a difficult process. I think the focus was just on providing high numbers on the outskirts, like I said. If you look at 1798, the Woodstock Hospital was not city-owned. If you look further, the Salt River Market was not city-owned. It was actually bought by Transnet, and the Woodstock Hospital was by the province. What the city did own was the park at the hospital. And if you go on to page 1799, you see that what they've released is the fruit and veg site and with that property. So Mr. Heron's guess to the journalist has been elevated to an admission of the city not having done anything, translating into a breach of constitutional rights. We submit that the test remain one of reasonableness, that this court has set out in the commando judgment what that standard must be, and I don't think I'd be of any assistance to take it much further with this court. But I do want to end on drawing the court's attention to 3 paragraphs of the High Court judgment, which deals with why there was no actual issue that the city's policies were reasonable. It's at 494 of the judgment, and the court quotes it as follows: "As far as the city is concerned, I am of the view that the evidence put up on its behalf, particularly by Mr. Molapo, establishes that it has done what it could over the years to provide affordable housing to the community, of suitable land at an affordable price, and notwithstanding its repeated requests to both national and provincial government to make such land available to it, to facilitate such availability, it has drawn the short straw every time. In that respect, one needs look no further than Mr. Lil's request to President Zuma and the city's expression of interest in the Tafelberg site for the provision of affordable housing." In the next paragraph, halfway down, reference is made to the interview with Heron, and then at 496 it says, "It is true that there are instances where the city has attempted to break down spatial apartheid barriers fairly close to central Cape Town. Example, Woodstock, Brooklyn and Maitland," and I took the court to Brooklyn and Maitland a few minutes ago. "But the city's inability to provide affordable housing in and around the CBD has largely not been of its own making. The evidence of Messrs. Bandezayo and Malapo and the interview with Mr. Heron suggests that the non-availability of suitable land at a fair price has been the city's Achilles heel. That having been said, the Heron's interview as city land could be utilized for affordable housing, and that it really did not take much to achieve that situation." And I addressed that latter proposition with the court. Those are my submissions.
No questions for you. Thank you.
Thank you, Acting Deputy Chief Justice. If I can begin with the question that I deferred from Justice Turon concerning the Joseph judgment. And I've had a chance to look at Justice Squilla's judgment and the extract from the Joe Slovo judgment that is quoted in that. And it is correct, Justice Turon, that Justice Sachs does talk of a cluster of legal relationships, but it would be my submission or my reading of the judgment in Joseph that the more poetic language used by Justice Sachs in talking of a cluster of legal relationships, one reads the context in which that is applied by this court in the more prosaic language used by the late Justice Squilla, it is clear that it's a reference to legal rights and not just a less concrete concept of legal relationships. With regard, there are 4 issues that I'd like to try and cover in that 8.5 minutes that are. I'd like to begin with Mr. Fagan's submissions with regard to the question of a pipeline. And I'm not sure if I heard or understood his submissions correctly, but I had the sense that he might have been suggesting that there were some projects in the pipeline that had been completed. And that is certainly not the case on the evidence before the court. If I can just refer to Mr. McCarthy's founding affidavit at paragraph 28, where he says clearly, unlike in Johannesburg, none of the developments undertaken in terms of the social housing program in Cape Town, save for the project in Woodstock, where land has been recently released, but that was still the pipeline project, were undertaken in the inner city or near inner city sites. And then Ms. Gooch, in her response to that, admits that that is the case in relation to the delivery of social housing. It's not in dispute that no social housing developments were developed in or near the inner city. And then I can just refer to Mr. McCarthy's affidavit in reply, and he does an analysis of the pipeline projects. That's at volume 29, and starting from page 3081. And he confirms that in the answering at paragraph 38, he confirms that none of the social housing built in Central Cape Town has been built, no social housing has been built in Central Cape Town since 1994. And then he does the analysis of the pipeline projects for the province and the city. And I'm not going to repeat the submissions that I made this morning, but there's one additional fact. He says that only 16% of the province's pipeline projects are planned in areas where there's significant social and economic integration. And then in his analysis of the city's project, I dealt with this morning, that they, apart from the Pickwick site, are in the embryonic stage and have stalled. There's no guarantee that these planned projects will materialize, or if so, how long they will take to reach completion. Then I'd like to respond to Mr. Fagan's submissions, the answers that he provided to questions from Justice Rogers. And firstly, with regard to when the province abandoned the regeneration program. And the first that we as the applicants knew of it having been abandoned was when province stated that it had been abandoned in March 2017 at the time of the decision not to resile. That was stated in the heads of argument in this court, but until that point there'd been nothing on the papers to indicate that this was the case. And then Mr. Fagan defended the position adopted by province on the basis that the case they came to meet was a case about a failure of implementation, not a case about a policy. In that regard, it was stated by the applicants, and the matter is primarily, and I emphasize that, about the manner in which policies have been implemented rather than the policies themselves. But then in the supplementary founding affidavit, it was made clear that once the province and the city had accounted for the manner in which they had conceived and implemented their programs, then the applicants would reconsider the relief that they seek. And in response to the answering affidavits, I referred earlier this morning, and I'm not going to repeat it, the applicants set out in the start of the replying affidavit a summary of their position, dealing with, firstly, with the difficulties with provinces' policies, then the difficulties with the city policies, and then with the failure of implementation. With regard to Ms. Barwer's submission that the applicants did not rely on Section 2 or difficulties with the case made out by the applicants in the founding affidavit, I'd just like to refer to page 61 and paragraphs page 61 of the record, that's volume 1, where the applicant set out the relevant provisions of the Housing Act that are relied upon. And this includes the Section 2 provision with the requirement to promote the process of racial, social, economic, and physical integration in urban and rural areas as spelt out. And then 2 pages later, at paragraph 122, Section 2(1) Roman 4 of the Social Housing Act, which deals with the need to promote social, physical, and economic integration in existing urban and inner city areas, is dealt out. So it is clearly spelled out. Both those provisions were clearly spelled out in the applicant's founding affidavit. With regard to Ms. Barwer's reliance on the development of social housing in Maitland and Brooklyn, as has been explained already, the core of the applicant's case, the basis of the case set out in the founding affidavit, was Mr. McCarthy's evidence that there was no social housing in or near the inner city of Cape Town. And once it became necessary to clarify what central Cape Town was, then Dr. Odendaal was brought in, and she gave her evidence. The statement made by Mr. McCarthy that there's no social housing development in or near the inner city of Cape Town was not disputed by the city in their answering. It stands uncontested. The difficulty that the city has with regard to Dr. Odendaal's definition is that it's not a broader area. So central Cape Town isn't expanded more broadly so as to include Brooklyn and Maitland, so that from that broader understanding of central Cape Town, there would be social housing that was developed. Thank you, Acting.
Justices. So Fagan for the province submitted that, I think it was with reference to the proposed order attached to NU's practice notes, that NU now realizes that the structural interdict is unworkable without the national government, and thus, if I took my note correctly, requires a report to be provided by all 3 spheres of government. So understood, that is not correct. The proposed order does not seek a report by all 3 spheres of government. NU's position is set out clearly at paragraph 37 of their heads of argument in response to series heads, where they say that the applicants have not sought to have the national government included in the structural interdict, this is the proposed interdict, given that no case is made out that it has failed to comply with its obligations in terms of the relevant legislation. These obligations are primarily to put in place the necessary legislative framework and to finance the development of affordable housing. And we agree with that submission, Justices. Fagan also submitted that, if I understood that submission correctly, that once IAMA came into effect and was made of application to national government in 2009 and the provinces in 2010, there could be, without compliance with IAMA, no further disposals of such property. That is, of course, an inevitable consequence of a law coming into application, non-compliance is thereafter prescribed, which is why when laws introduce significant changes to the legal landscape, there are normally introductory periods for persons to get used to that. That is precisely what happened in this case. Even though Guillaume was introduced in 2007 and commenced, published in 2007, its date of commencement was delayed so that all affected parties could acquaint themselves with its provisions. Hence the passage of time between 2007 and 2009 and 10 respectively. Quite apart from that, I draw the Court's attention to Section 15 of Guillaume, which deals with exemptions and authorises the Minister by notice in the Gazette in respect of certain immovable assets or categories of immovable assets to exempt any organ of state from any provision of Guillaume for a period determined in the notice. And lastly, in this regard, Section 22, which provides that the Minister may, by notice in the Gazette, suspend any requirement in terms of this Act for a transitional period to facilitate the implementation of the Act. So there were all those provisions available, Justices, and once again, if any of the other spheres of government or any sphere of government felt unable to comply with Guillaume within whatever time the legislation was due to be of application to them, that would have been an aspect to take up in terms of intergovernmental processes to that end. And then there was a submission with reference to Section 13.3 of Guillaume, and if we understood the submission correctly, Fagan referred to Section 13.3 as indicating what Guillaume had to say about the ability of, or the power of a custodian to dispose of a surplus immovable asset. 13.3 provides that that can be done by the allocation of the asset to another user or subject to the State Land Disposal Act and any provincial administration law by sale, lease, exchange, etc. We submit that that is not an empowering provision so much as simply an indication of a modus as to the manner in which a disposal takes place, and nothing further should be read into it. Then Mr. Fagan posed what we trust is a rhetorical question: what purpose would a declaratory order at this point serve, apropos the failure of, in our submission, the province to comply with its constitutional obligations under Chapter 3 of the Constitution, now that the Tafelberg property has fallen, the sale has fallen through? We submit that the purpose to be served by such an order would be the principal one that this Court is here to see to, and that is the upholding of the principle of the rule of law. And the Court is enjoined to do so in terms of Section 172(1)(a) of the Constitution. The fact that you make no consequential order thereto does not detract from that principle and principial obligation. Fagan also referred to the fact that there was no obligation to consult the national government to be found in Guillaume. While there is no such express provision, we've made our submissions in our written arguments. But what I would, the point I would make is that Section 4 of the Western Cape Land Administration Act expressly requires coordination when the Western Cape government disposes in relation to any conduct by the Western Cape government in respect of land which falls within its jurisdiction. It requires the Western Cape government, in dealing with its own land, justices, to coordinate its activities with those of other spheres of government. So the obligation, we say, quite apart from anything else, is to be found in Section 4. And then the last submission I want to make, Mr. Fagan submitted to the Court, and he put submit a gloss on what happened. He said that there were negotiations for the Provincial Department of Human Settlement to withdraw their interest in the Tafelberg property. There was no such negotiations. There were no such negotiations, Justices. You will not find any reference to negotiations on the papers, and that simply does not accord with the facts. I'm not going to take the court to it, but when the court looks at the papers, the affidavits, and the correspondence, there was no negotiation. And in any event, none of that detracts from our arguments about what a proper interpretation of Guillaume required, i.e., human settlements had to act in accordance with the UAM, which was not included. Those are our submissions. In reply, we persist with the relief that we as a court purpose. Indebted to the court.
There's a question. The issue that was raised justice focus. You want to please respond, or do you want just reintroduce
documentation? I've got an instruction in the meantime. I'll do so. Obviously, as soon as possible, we will provide documentation to the court, to
whether it's a court found that it will require a procedure at least to make its current policy available to do so, or you say whatever the relevant documents are, they are already finished to the evidence.
Understood. Any suggested that was provided to the court, but
it's not reflecting what you're planning to intend to say. The coverage policy.
Thank you, Mr. Speaker. Many thanks to all counsel. Judgment is reserved.